With your lordship's kind leave, this matter may be listed tomorrow or day after tomorrow because this is a factory closed since 3 years on account of the hardest passed by the fifth respondent.
Account of when the order was passed.
This was passed about a year back.
Then now all of a sudden,
Now,
Let
what
it-
happened? Number of employees are unemployed. And
after 3 years you are coming.
my lord, due to certain reasons, it could not be filed immediately.
No problem, but then let it be listed through office, you listed within 5 days. Once you remove the office of this,
Any convenient date may be.
you file and wait for 5 days. If it is not listed, mention again, yes.
Your Lordship, this is contempt petition. Office objections complied. If your Lordship kindly list this matter on 24th of this matter, it would be much beneficial because my shares, your Lordship, it's partly sold by the respondent company in spite of interim order.
Oh, so what do you want?
24th. 24th.
24, serial number 24.
Lordship, I want the case to be listed on 24th.
No, it can't be. Your choice. It will be on 10th March.
Serial number 21, my lord.
20?
21.
21.
We are requesting to adjourn the matter, my lord. Senior's daughter's marriage, my lord, is not in station, my lord. We are requesting to adjourn.
All right. When shall we keep? It will go to
Kindly have it on. the
25th of March as requested by learned advocate for the appellant.
My lord,
My lords,
number 26,
26, yes.
not adjournment.
26, 29th, 28th of March. As
My
requested
lord,
by
requesting
learned
for,
advocate appellant.
my lord,
matters for posting, my lords. There are fresh petitions, 3 fresh petitions filed by the crusher owners, my lords. What has happened? The Pollution Control Board has passed an order for closure of the crusher board, stating that it is not in the safer perimeter. Thereafter, my lords, after the order, the zonal commissioner has inspected the spot and he has given a clearance certificate and has also directed the Pollution Control Board to revoke the order. The order was passed on 20th January. Till date, it has not been revoked, my lords. It's been more than a month. We are not running the crushers.
10th March.
That's a
My lord,
shorter date, my
request-
lords. Because it's been closed since in the past 1 month.
my lord, request for posting a fresh matter, my lord. It's a request for posting a fresh matter. It's a writ appeal, my lord, filed against the order of a honorable single judge, wherein my lands have been directed, the revenue records to be transferred to the name of the petitioner without even making me a party to it, my lord, where the petitioner has misled the honorable court. Therefore, my lord, the order was passed on the 20th of January. Immediately come before this court, my lord. If it can be kindly be taken up, my lord.
You may the office officer and wait for listing. No memo, yes.
My lord, serial number 28. I am for the appellants. I seek an adjournment, my lord. Personal inconvenience. Serial number 28, my
At
lord.
the request of learned and appellants, 10 to 1st April.
Much ob-
Serial number 84, not
84.
I have filed a memo for withdrawal. Order is compliant.
24 is contempt petition 123 of 24. Learned advocate, Mr. Your Maya Supin
Yes.
states that he has filed memo of withdrawal of the public figures on record. First opinion of the memo. Permission is granted to withdraw the contempt petition. Petition is dismissed. Memo ka date.
My lord's kind permission.
Yes. Yes. Yes, Mr.
Milord, item number 23, Milord. Any day, your
23.
lordship's convenience. I have some difficulty today. Can it be next week, Milord?
Not next week, you will go in March, 21st March. As requested by learned
Or
advocate.
can it be on the 19th, Milord, if it is not
19th.
inconvenient?
19th March. Okay.
19th. Obliged.
Serial number 8 in this case, ma'am. The previous time in this case. Serial number 8. Let's adjournment. In this case, ma'am. The counsel who is appearing not well in this case.
Which one?
Serial number 8.
8.
8. Please post this matter on Friday, 21st.
Let it be called out, we'll see. You be here.
Yes. Any other mention through VC, sir?
Time permits. That of matters.
So, list number 1, contempt matter, seal number 1, to Varun RR.
That's the honorable single judge has directed the KIDB to comply with the order, my lords. Till today, it is not complied.
Where is the direction? It is.
My lords will find it at in page 15, my lords, annexure A.
Oh.
My lords, in para 4, my lords, there is a direction that KIDB has to consider the
Read it. Read the direction.
My lords, please. The writ petition stands disposed of with a specific direction to the third respondent, Special Land Acquisition Officer KIDB, to consider the grievance of the petitioner for a grant of compensation on the ground that the petitioner is the owner of the 1 acre in survey number 37 of so and so village. Please, my lord.
So no time limit is there.
No time limit is specified, my lord.
The direction which are sought to be brought under the contempt.
Next para is
Next.
important. But his name is not my lord. Lord, unless my lord, the name is
So,
not
correct. So have you done your part of
But,
obligation?
it is still pending, my lords. We have pursued.
Then there is no contempt.
Okay, time limit may be specified.
Where is the contempt? You are supposed to go to the Tehsildar, then get your name mutated in the records. Then the role of special,
Please,
Land
with
acquisition.
that direction, it may be
it
disposed.
is already there. You have to go before the Tehsildar, get your name entered in the records. The same can be brought to the notice to Special Land Officer, and then this will operate.
Please,
So what do you propose? Inviting order?
lords, with the same direction, it may be disposed.
We are not entertaining the petition. Have you done your public part?
Lords, it is still pending. I'm instructed that it is still
The following
pending.
are the directions which are brought under the contempt jurisdiction of this court by filing this contempt petition. From as found in order dated 3rd August 23 of
Lords,
Learning Single.
May I, my lords, apologies. May I seek for a short accommodation, my lords? I'll
No.
verify once.
Paragraph 4 quote karo. Full stop. The bare reading of the aforesaid direction would go to show that before the direction given to responsible Special Land Acquisition Officer to consider the grievance of the petitioner for grant of compensation operates, the petitioner has to discharge his part of obligation by approaching the Tehsildar and getting the name entered in the land records. Full stop. When the query was put in this regard by the court to learned advocate for the petitioner, Mr. So and so, he was entirely at his receiving end to be able to submit only that the said proceedings are still pending. Full stop. In that view, the question of compliance of directions issued to responsible Special Land Acquisition Officer to KIADB does not arise, since the other part of the requirement is not completed. No contempt is made out at this stage. The petition is misconceived and this is dismissed.
My lords, liberty may be reserved to.
It is always.
Please.
Obliged.
Seal number 2, SB Mukanappa.
Notice
Right.
returnable on 17th March.
My lord, the respondent accuser number 1, 2, 3 is the government advocate.
1, 2, and 3 is
The accuser number 1, 2, 3, they take direct to government advocate.
if they are
Notice to
accepting, well
respondent
and
number
good.
5.
Not accepting, you have to serve.
I'll take notice to respondent number 5 minutes.
Learned addition government advocate. Srimati Nilo, Srimati Pramodini Kishan, accept notice on behalf of number 5.
5.
Seal number 3,
My lords, I appear for the
V. Akshay
petitioner.
Kumar Jain.
My lords, the order is at page number, contempt petition, my lords, order is at page number 22, where this honorable court quashed the ECIR proceedings, based on which I wrote to the enforcement directorate requesting my assets to be released.
But in any case,
28.
again, it is open direction.
Please, my lords, I moved a clarification seeking a,
Open direction. There is no something is.
my lords, I've written multiple times to them and I haven't even.
Where you written?
My lords, may please come to page number 24. I wrote to them on 1st February 24 requesting for my assets to be released. I received no reply.
So
Then I filed an application at page number 25.
did you specify the time limit for releasing of the asset?
My lords, I didn't specify the time. Lord, there was no time limit given, my lords.
That is the law. If the direction doesn't provide for time limit, you must issue notice to the.
My lord, I've issued
authority concerned,
multiple letters
set a
of,
time limit for it. Thereafter only you can invoke the contempt jurisdiction.
lords, I've written multiple letters. I've moved clarification before this court at page 23. This court has clarified that my assets, digital assets seized during investigation.
Learned advocate so and so for the complainant. Following directions in order of law and single judge dated 20th December 2023, read with the order on being spoken to dated 27/9/24 are subject matter of contempt jurisdiction. Full
Even
stop.
after
The
this-
directions read as under this bracket and this bracket, full stop. Respondents are placed under obligation to release the assets and devices seized from the petitioner. Or like it is forthwith. It is forthwith. Will issue notice.
Lords, Mr. Unnikrishnan M had appeared for the respondents 1 and 2 in the contempt, I mean, in the writ petition, my lords.
Full stop. The direction is to be complied with by the respondents forthwith. In that view, notice returnable on. When shall we keep? 18th March.
Much.
Serial number 4, the Narayan MS.
Notice returnable on 21st March.
In this matter, my lord, for the formation of the road, they have acquired the property, my property, they have not given the TDR right, Your Honor. High Court has, in the ink page number 20, my lord,
One sec.
respondent directed to represent
where
within
is
2 months.
this?
It has
Notice
been given. I am
returnable
given the represent.
18th of March.
Serial number 5, the Ravindra Road.
The sub direction is for the Tahsildar to appoint a licensed surveyor and to obtain a sketch.
40.
Base pilots, 40.
Notice returnable on 19th March.
Yes, any short date may be given. my lord.
Not possible.
Pleasure.
Serial number 6, the Siddharth Suman.
Appear for the complainant, my lords. There was a contempt of, there was an order passed by this honorable court on 27/1/25, my lords, asking the bank to deposit the money along with interest within 7 days of the order. We have sent them a legal notice as well as an email with regards to the order. It's been quite some time and they've not deposited, my lords.
Number 1 is bank. Who is number 1?
Bank, my lords,
Notice returnable on.
represented by the chief manager.
Notice returnable. 19th March.
Please.
Serial number 7,
I appear for the
P. Kumar.
tenant. The order of the single judge is at page 14, my lord. And the relevant is at page number 24, my lords. But there was a direction to the respondents to, my lord, sanctify the change of KEDA, my lord.
Notice returnable on 19th March.
May I make one request, please? Can I, take a hand delivery of the
Service by hand delivery is permitted.
great.
Notice for,
Service of notice by hand deliveries.
I take notice.
Call
for
number
respondent
3 is,
my
my
lord.
lord, state government.
Notice for respondent number 3. I take notice for
Learned
respondent.
advocate, learned additional government advocate, Mr. Raghavendra, accept notice. Number 3.
For R3, my lord.
Yes,
That's three.
yes, great.
So PL matter, seal number 8.
Memo for petitioner.
Ravindranath K.
So you wanted time here.
Yes, ma'am. Council is not well on this Friday.
So they are using for, are you ready with the matter?
No, my lord. Please on Friday this one.
When shall we keep? When shall we keep? When shall we keep?
Friday, ma'am.
Friday.
Seal number 9. With Chetan Gowda.
For the petitioners to lodge. My lords, this petition is challenged, my lords, the illegal and arbitrary grant of the occupancy rights by land tribunal Chamrajnagar. My lords. 21. The property, my lords, the property in question, my lords, it belongs to the Chaudeshwari Ammanavaru, my lords. It is the deity's land. It is granted to the respondent number 4 here.
So you want to set aside annexure title,
Please.
it's a title document.
Please, my lords.
So you have to go to civil court.
Sorry, my lords.
It can't be set aside in this public interest petition.
My lords, I kindly request your lordship to,
It's a title document,
please, my lords.
page 24. Title deed for grant of land under 77A of the Karnataka land reforms.
Please.
Can't be set aside here.
My lords, here, my lords, may kindly see, my lords. My lords, the respondent number 4 here, my lords, is not even a regular Archaka of the temple, my lords, the temple in
Whatever
question.
illegality or irregularity or grievance you are raising, your relief of setting aside this title deed cannot be granted here. In every jurisdiction, that too in public interest.
My lords, may I kindly request a short accommodation, my lords? I'll submit, my lords. I'll convince your lordship as to. My lords, the existence of temple is in question, my lords.
Mister,
Please,
you want it to be dismissed with cost, is it?
no, my lords.
No, see, listen, it is such a vexatious litigation. A person makes an application for recognizing his tenancy rights, and it is granted in his favor. Now you come up and say villagers were tilling the land and contributing it to the temple. What type of writ petition is this?
Whereas the villages have been cultivating the land in rotation.
Who is cultivating the land? It is simply because you don't have a right over the land. Your right has been terminated. You have filed this particular writ petition to harass the person in whose favor the land has been granted. That's all.
That is not the,
You want to invite an order?
no, my lords. Apologies.
Do you want to withdraw?
Please, my lords. My lords,
Don't
one
interrupt
submission,
me.
my lords.
After,
Can I please seek a short accommodation, my lords?
there is no question of accommodation.
My lords, I'll file my memo regarding the withdrawal also, my lords, please. Within the next date of, I'll just seek instructions and I'll withdraw, my lords.
You can come at 2:30, not beyond that. Today, 2:30,
Please, please,
2:30.
match up.
For the petitioner. The petitioners are before this honorable court in second round, my lord. My lords, in the earlier round of litigation, my lord, this honorable court granted liberty to the petitioners to file a representation before the concerned authorities. My lords, may kindly take annexure G, page 166. Because in page 166, annexure G, my lord. My lord, in pursuance to that, my lord, I have filed the representations before the concerned authorities as per page number 169, annexure H.
One,
Annexure 169, annexure H, Miller, 169, annexure H. I have given the representations before the government to consider my representations, Miller. Those representations have not been considered. My only limited request before its honorable court is to consider my request, what I have made to the concerned authorities, Miller.
Are you members of the society?
Lord, I am not a member. I belong to a social weaker section of the society. Lord, the purpose for which the society is formed, Millards may kindly, the society was formed on 22/6/1936. It is named as Arijan Sevak Sangh. Millards may kindly take the preamble of the society, Millards. Millards may kindly come to annexure A, page 32.
No, come to your prayers. You have asked for
Millards, what has happened is, Millards,
inquiry into
it runs to several crores of properties is being given to the Arijan Sevak Sangh.
fourth respondent society. Fourth respondent is not a society, it is register of societies.
I have given a representation to them, Milord, to consider my request. Milord, my lords may kindly come to preamble of the society, Milord. The purpose and the object for which it has been page 32, Milord. Page 32, annexure A. The following, Lords may read. The following resolution among the others was adopted on behalf of what are known as caste Hindus by meeting of their representatives from all over India held at Bombay under the presidentship of so-and-so on 5th September 1932. The conference resolved all these things, Milord. Thereafter, Milord, the state has also formed a society, Milord. Milords may kindly come to annexure B. The translated copies are at...
where is the society as party?
It's a society, Milord.
Which?
Lord, it is the sixth respondent is the Karnataka State Arijan Sevak Sangh. Sixth respondent is a party, Milord.
If you want to pursue a representation, do it. Otherwise, you are not inclined.
Milords?
You want to pursue a representation, do it independently. Otherwise, this is absolutely vague and
Milord,
absolutely useless petition. No details whatsoever. You
Milord,
just
I have
make
given the
a,
complete...
just make a 2-line and file a public interest petition.
No, Milord, I have given the complete details, Milord. Milords may kindly turn to...
What do you want? We are not inclined.
Milord, I have no other remedy at all, Milord.
Maybe that is not our business.
Milords may kindly see, Milord, several crores, Milord, crores of properties is being given to the Arijan Sevak Sangh for the purpose for which...
Lord Learned Advocate Mr. So-and-so for the petitioner. Full stop. The petitioner's claim to be...
I may be permitted to withdraw, Milord. Liberty may be reserved to give a fresh representation and I'll come back, Milord.
Go, you pursue representation. Withdraw and pursue.
Milord, I will withdraw the petition, Milord. Liberty may be reserved to give a fresh representation.
Learned Advocate Mr. So-and-so seeks permission to withdraw the petition, stating further that the petitioner may be given liberty to make a press representation, full stop, reserving such liberty. The petition is dismissed as not entertained. However, with regard to the proposed representation and the merits thereof, this court does not express any opinion on merit. Any opinion?
Still number 11, R. Srinivas Gold.
Serial number 10.
I'm for the petitioner.
This was which? This was 9. No, 9.
Blood, I'm for the petition. Blood. This matter, total extent of survey number 43 of Kachwali.
What is this?
Blood, total extent of survey number 43 of Kachwali village is 44 acres, 30 guntas. Out of which 20 acres, 24 guntas is encroached by various persons. Blood, the government is not taking any steps to recover that land from the encroachers. The representations you are made, blood, they have not taken any action. It is within the BBMP limits, millards. As admittedly, millards, as per the government only, millards, that much extent is encroached. Annexure B, millards.
Your grievance can be agitated before this Karnataka land grabbing authorities.
No, millards, we can't fail, millards. They have to, millards. Government is to initiate proceedings under the act, millards.
So make out a case and we'll see that.
Millards,
to look into it.
millards, Annexure A is the RTC, millards.
What is that?
Page number, translated copy is at page number 31, millards. In that, millards, total extent, millards, column number 3. 52 acres and 41 acres is Kharab. Then, millards, column number 9, millards, government Gomal, 27 acres, 17 guntas. But then, millards, Annexure B, millards. Translated copy is that original copy, millards, is Annexure B, page number 41. In that, millards, page number 42, millards, it is said, millards, for 20 acres, 24 guntas is encroached, bottom, millards. Translated copy of the same is that page number 50, millards, page number 50.
Have you made unauthorized occupants a party to the proceedings?
Because we can, before the land grabbing, but the government, because we can't identify how much they have encroached and all. So as per the records, millards, 20 acres is encroached.
Third learned advocate, Mr. So and so for the petitioner and learned additional government advocate, Srimati Nilofer Akbar, who appears to assist the court upon service of the copy of the petition in advance. Paragraph, styled as public interest litigation. The petitioner, Karnataka Janata Vedike, who is president, to raise a grievance that inter-alia that the land survey number 43, total head measuring 44 acres and 30 guntas, which is at Pachohalli village, Dasnapura, Hobli, Bengaluru North Taluka, is encroached to the extent of 20 acres and 24 guntas. It is the case of the petitioner that the encroachers are the land grabbers within the meaning of Karnataka land grabbing into prohibition, bracket over Act 2011. It is the further say of the petitioners that despite the act of encroachment and despite the act of alleged encroachment and alleged land grabbing, the respondents have not taken any steps since last 14 years. It is the contention of the petitioners that it is in the public interest that the action under the law against the alleged land grabbers are initiated. Petitioner has stated, paragraph, that the land in question is of very high, is highly valuable land, and that the authorities have harbored fraudulent intentions not to take any steps and are not interested in protecting the public property, which is, according to the petitioner, evident because of inaction on part of the respondents. On such basic premise, paragraph, the prayer is made to direct the respondent authorities to initiate the proceedings against the alleged land grabbers, public encroachers in the said land, and to evict them to utilize the land for public purpose. It is the next prayer to direct the respondents to delete the illegal revenue entries which stand in the revenue record in respect of survey number 43 of Pachohalli village. Full stop. Whether there is an encroachment or not, and if there is an encroachment, it is to what extent?
20 acres, 24.
Furthermore, whether the encroachment amounts to land grabbing and whether the persons who are occupying the land are land grabbers within the meaning of the provisions of the Karnataka Land Grabbing into Prohibition Act 2011 are all questions which require effectual inquiry. Full stop. The exercise of inquiring the issues factually cannot be undertaken in the public interest litigation and in jurisdiction under Article 226 of the Constitution. Full stop. The petitioners would pursue the grievance by making appropriate representations.
Representations were made by us.
The petitioner to the authorities who may examine the facts which may have been put by the petitioners in the above regard, and to finally decide as to whether any action is to be contemplated under the Land Grabbing Prohibition Act against the alleged encroachers. Full stop. At this stage, learned advocate for the petitioner stated that the representation is already made to the respondents several occasions on 5/7/24, 31/7/24, and 1/8/24, as well as on 2/8/24. Post of responding to this, learned additional government advocate submitted that the competent authority respondent shall look into the representation, examine the facts, and take an appropriate decision in accordance with law with regard to what is submitted by the petitioner in the representation. Full stop. Providing that the exercise of looking into representation and taking an appropriate decision in accordance with law shall be completed preferably within a period of 6 weeks from today. The petition, the present petition is not entertained. Full stop. Nor the court has gone into any aspect of merit of the case.
Green bench matters. Seal number 12, Harish Kumar MS.
My lord, I appear for the petition. My lord, the petitioner firm it has been running a poultry farm. My lord, it has approached the pollution control board and obtained the consent order. My lord, wide annexure B, a sum of rupees 3,60,000 rupees fee was fixed and taken. My lord, subsequently, the relevant rules have been amended. Thereafter, my lord, the department has issued.
Appeal is pending.
Appeal is pending, but there is
But there in
no
sitting.
chairman is not there. There is no sitting for want of chairman. That is the reason, my lord, I have filed the writ petition seeking an interim order. Because the pollution control board, they are threatening.
Chairman is appointed.
Appointed.
When?
Pollution control. It's
When?
appointed. February first week, your lordship.
Maybe first week. Then direction may be issued.
Learned advocate for the petitioner seeks permission to withdraw the present petition dismissed as withdrawn with liberty to the petitioner to seek appropriate relief in accordance with law in the proceedings of fifth pending appeal before the Karnataka State Appellate Authority.
In view of the appointment of chairman, my ground is that only for want of chairman, I have filed this writ petition.
Are you sure, madam?
Please.
Full stop.
Much.
Pereira, in course of the hearing of the petition, countering the only ground that the petitioner has no remedy in absence of the appellate authority. And in view that the appellate authority is not functional, learned advocate Ms. So and so and so.
Tashi. For Mahesh Chaudhary.
For Mahesh Chaudhary, for the State Pollution Control Board's made a statement that the chairman is already appointed and the appellate, what is it? Appellate tribunal. Appellate tribunal is already functional. In the above, in overview, from a learned advocate for the petitioner seeks permission to withdraw the petition to approach the tribunal, appellate authority in the pending appeal to seek appropriate relief in accordance with law. Full stop. The permission is granted, the petition is not entertained without going into the merits of the case of the litigation.
Seal number 13.
That I appear for the
Philip
petitioner.
Chidanand.
Order challenge is, my lord, calling upon the petitioner to pay rupees 20 crore 68 lakhs of the illegal quarrying operation alleged to have been conducted by the previous owner of the property.
Yes.
Led. Previous owner, Mr. S. Ravichandran Miller, on the basis of the working permission given by the Director of Mines and Geology, was conducting the quarrying operations. Led, he offered to sell this property to the petitioner, Millard. An agreement of sale was entered into between the petitioner and the landowner, annexure J, page 135. Millard.
So this penalty is because of your illegal extraction in the
No,
past.
Millard, not by me, Millard, by previous owner. Millard. In fact, I have purchased this property in the execution of the decree in OS number 95 of 2020. The sale deed was executed in my favor, Millard. I have produced a copy of the sale deed.
Where is that sale deed?
Yes, sale deed is, Millard, Kannada lies at page 1, the first sale deed, Millard, your lordship get annexure M 183, Millard. The translated copy, Millard, your lordships will get. at page 191 minute. But I purchased this property in execution of the compromise decree minute on 12th October 2020. As on that date, Millard, there was no liability, there was no charge on the property, and there was no arrears of the royalty charges by the state government. Millard, when I made an application for grant of
You are
quarrying,
saying the penalty is recoverable from the erstwhile.
erstwhile 21.5 Millard is very clear, Millard, of the 21.5 of the MMDR Act, Millard. Millard, whoever conducts illegal quarrying operations alone is liable to pay. Right, 21.5 just may I read. And secondly, Millard, under 55G, Millard, as on the date, if there was no charge, Millard, I cannot be held accountable. Millard, this your lordships are aware, Isha Marbles, Shreya Paper Mills, Millard, Supreme Court in series of judgments held, Millard, subsequent purchaser cannot be held liable for the previous liability, statutory liability of the previous owner of the property.
My lord, please take paragraph page 210, my lord, or page 194.
Yes, internal page 34.
Yes,
In the event of any legal dispute.
yes, yes. He has to proceed against his vendor. He cannot deprive the state of its revenue because he was not diligent at the time of getting the sale deed executed in his favor.
Millard, as on the date when I purchased, Millard, there was no arrears of liability, Millard. Only when there was no arrears, Millard, all the royalty charges have been paid.
On one hand, you are saying that you are not liable to pay the earlier due.
The reason is,
now you are saying that there is no liability.
Millard, in fact, subsequently, when I made an application, Millard, in order to ascertain the area where the land is located, they conducted a drone survey and found that my previous vendor, Millard, my vendor has conducted the illegal quarrying operations. Millard.
My lord, as admission is enough for my lords to dismiss the writ petition. His vendor has, my lord, quarried, but that fact has not been informed, or the petitioner, my lord, the petitioner was not diligent enough to realize, to see that the property is not unencumbered.
Millard, as on that date, Millard, there was no liability at all, Millard. Liability came, Millard, only when, kindly see, Millard, when the liability was started, Millard, it is at page, Millard, 285, Millard. That was on, Millard, 17/9/2022, Annexure Z, page 285, Millard.
That is when it was discovered.
Was there any decree? Decree.
My lord?
Decree was there, decree of the court.
No decree.
Millard,
My lord, in the original suit, there was a compromise for agreement to.
He was regarding the specific property. He had filed a suit. You were raising your phone. You just no, the rules imposed by the state control is because greater exploitation than the permissible limits regarding the public concern. Here also it was committed for this. I know that. They didn't do it for mining purposes. So they will report it as arrears of land revenue. Now, he purchased the virtue of the compromise between the court as against earlier.
Two provisions, Millard, section 55G of the Transfer of Property Act, section 21(5) of the MMDR Act. These two provisions make it clear, Millard, whoever conducted the illegal quarrying operation alone is responsible, Millard. Millard, first 21(5), may I draw your lordship's attention?
21(5).
Please, of the MMDR Act. Yes. Whoever any person raises without any lawful authority any mineral from any land, state government may recover from such person the mineral so raised, where such mineral has already been disposed of. The price thereof may also recover from such person rent, royalty, tax, as may be for the period during which the land was occupied by such person without lawful authority.
Ah.
Milad, the charging section for the royalty, milad, under the KMMC rules, milad, Rule 36 of KMMC rules, milad.
You should have made your vendor a party to the proceedings. See, government is entitled to its money.
Yes, it entitled from. his
It's
previous-
either from you or from him.
Yes, milad.
It's either from you or from him.
Yes.
And there is a clause in your sale deed which says that in any such eventuality, he has to reimburse you. You make him a point. You have not made him a party to the proceedings.
I'll make him a party.
You have stepped in the shoe of that party.
Yes,
Milad,
my lord, yes.
Your Lordship, 55G, your Lordship may kindly see, milad, two judgments of Supreme Court, milad, Isha Marble Saya paper mills. Yep, milad, as on the date, if there was a charge on the property, milad, then the vendor purchaser is liable. But here the charge itself came thereafter it was on 17/9/2022, milad, after 2 years of purchase of
It all
property.
depends on the terms of the conveyance.
Yes.
And there is a specific condition in
Yes,
internal page 34, page 190.
yes.
That you have to, it is not.
He indemnifies.
With encumbered, yes.
Milad,
And
there
here
is
you
no-
join, learned advocate, Mr. So-and-so wants to join whom?
The previous landowner.
The erstwhile lessee.
Please.
As party respondent, post title may be amended accordingly. Once the amendment is carried out, there shall be notice to the newly added party by the registry returnable on 26th March.
Please.
Number 14, Mr. Abhijit, yes. Mr. Abhijit,
Hello.
yes.
Yes, Mr. Abhijit. Abhijit. What is it?
Mr. Abhijit, seal number 14.
14. You are not.
Hello, to represent the petitioner in this case.
Mr. You are not
Sir, you
audible.
are
Seek for an
not
ad-
audible, sir. Not speaking.
Not audible. Either we are keeping back or you come physically, whatever.
A date may be given, my lords. As
Pardon?
there is a medical emergency, my lords, I have to leave immediately. A date may be given, sir.
All right, give some date. March will be given in March. 19th
Yes, sir.
March.
Yes.
The rate appeal matters, seal number 15. Sir Ramatullah Kotwal.
For the petitioner in this case, Your Lordship. The petitioner herein is challenging the order dated 27th May 2024 passed by the learned single judge. Your Lordship, the petitioner institution, that is Jamia Masjid, managing committee of the Jamia Masjid, Your Lordship, is gazette notified institution, wide annexure C, page number 181, Your Lordship. Lordship, may kindly peruse page number 181.
at serial number 258. This particular institution is specifically granted the land, that is survey number 2, for specific purpose of Kabristan, that is graveyard, your lordship. Kabristan and Sunni. Your lordship may kindly peruse annexure E, that is the certificate of registration, page number 83. Your lordship may kindly find the particulars of the work property. Land number, that is survey number 2/1A, Mulkalmuru town and Taluk, Kasaba Hobli, extent of 1 acre, arising out of 5.9 acre. That is particularly vested for Kabristan, Mulkalmuru town and Taluk Chitradurga. It is particularly vested for the purpose of Kabristan, that is graveyard, your lordship. Your lordship may also peruse annexure Q, that is at page number 129.
So delay and suit. Your suits were dismissed in the year
2017. Your lordship, it was not challenged because due to the parallel proceedings, your lordship. Parallel proceeding was running before the Honorable Karnataka Appellate Tribunal. For that reason, it was not challenged, your lordship.
That was after 10 years.
Please, your lordship.
That proceedings were after 10 years.
Your lordship, that was not challenged because the deputy commissioner, that is respondent number 3, has passed an order in 2006 without issuing a notice on us, your lordship. We didn't had any kind of knowledge of this particular proceeding, your lordship. After obtaining the knowledge, after seeing that the construction was carried on in this particular suit premises, we approached the Honorable Work Tribunal and before the Appellate Tribunal, your lordship.
Sorry.
Your lordship, we had no knowledge of it, your lordship, for 10 years. They have not even made us the parties
10
to
years
this
is
proceeding.
too long a time to believe that you had no knowledge.
Your lordship, when they started to put up the construction, then we came to know, your lordship.
Sorry, dismissed. Grateful.
Number 16 to Munish Kumar KB.
I'm for appellant, my lord.
Delay.
Apologies, my lord. My senior is before Kalburgi branch student tomorrow.
Delay is there, will issue notice 134 days.
IA1 maybe, IA
Notice
for
written
condemnation
available.
delay. And on,
24th March.
deeply obliged.
Number 17 to Shrikara PK.
She was applied from BWSSP for obtaining building plan.
Delay 16 days.
Delay 16 days.
Any other party than government?
Government will take notice.
BWSSP is to be served, my lord.
So notice written.
Three matters, 17, 18, 19. all the
17,
three
18 and
matters.
19, all three. my lord.
Notice in all.
And my lord, they may have to be connected
Returnable on 25th of March.
and they may have to be connected with writ appeal 867 or 24. Writ appeal 867 or 24.
When it is going to go to?
Date is.
So on that day you may request.
I'll do that. No problem.
Seal number 20. Mr. Joseph Kanikraj.
For the applicant, there is a delay of 106 days in filing the appeal.
Notice. 26th of March.
The respondent has entered caveat.
Only respondent.
Only sole respondent.
Only respondent. Who is?
No, only respondent in the sense family members. A single counsel appears for all the three respondents.
So delay can be condoned if he comes.
Yes, ma'am.
So keep asking. Three respondents. That is what I am asking. So the caveat is filed by all the three respondents.
For all the respondents. For all the three respondents. Two respondents are minors, represented by their mother.
And keep it because the counsel to be here.
I'll inform him.
What is the delay?
There's a-
106 days.
106 days. The reason being, my lord, I had preferred a review petition. I have challenged the order dated 16/4/2024, passed by the learned single judge in writ petition 45719 of 2015. Immediately thereafter, on 28/6/2024, I had preferred a review petition before the learned single judge, which came to be disposed on 5/8/2024. Immediately on 30/8/2024, I have preferred this writ appeal. Therefore, the delay of 106 days in filing the appeal.
Let him come.
Please, ma'am.
Ask him to be here to recall him.
Please, ma'am.
Twenty-one is urgent. Seal number 22. Mr. Keshav Bhatt.
Is there.
Anybody? Notice will have to go.
Notice, sir. My lord, R7 has entered caveat.
20th March, notice.
23 is urgent. Seal number 24. State appeal.
24 state appeal, my lord, there's delay, my lord.
Notice. Notice returnable on 26th March.
So 25. Mr. T.P. Mutana.
I appear for the appellant, my lord. In this case, my lord, that respondent was working in RBI. And my lord, that after, and he was deputed to that one subsidiary of RBI, that is known as DFHI, Discount of Finance House of India. And from there, he has worked for, he was deputed for 2 years. After 2 years, my lord, DFI, and one of the conditions for deputation is, after 2 years, then that they issued a circular for absorbing those persons who are on deputation in that company. And there are conditions, one of the conditions, my lord, I have mentioned, the condition number 10, my lord, that page number 14. Superannuation benefits, 14, page number 14, para number 8. Superannuation benefits other than pension will continue to be admissible to the members of the staff to the extent as per the existing rules obtaining the Reserve Bank of India until such time as the Discount and Finance Housing Limited frames its own scheme. The superannuation age will be 58 years, except in case of the employees class 4 and so. Next, the Reserve Bank of India staff regulations will be applicable to the members of the staff in respect of all the matters until such time Discount and Finance House of India frames its own rules. As and when Discount and Finance House of India rules are framed, same will be applicable to the members. Respondent number 2, my lord, he opted to become the employee of that DHFI. And then he submitted the VRS to RBI. He was there, he worked for about 23 years, and RBI, he is getting the pension from the RBI. Then after joining this, my lord, that this and all, then the DFI framed the regulation on 24/7/95. As per the regulation, my lord, that and that defendant and the respondent is also accepted the terms and conditions of the regulation. And then after he continued in that DFI.
Issue notice.
My lord, this one stay is required, my lord, that.
What stay?
stay because that learned single judge has ordered for giving the pensioner benefits to him. And there is no pensioner benefit in this company at all. That last part of the operative portion of the order, my lord. And according to this facts of the case, he is not entitled for anything because he has been absorbed by the company. Last part of the letter. The writ petition is allowed. That is page number 64, my lord. As a result, respondent 3 is directed to pay a differential amount of pay and allowances to the petitioner by granting the pay scale and allowances on par with obtaining the Reserve Bank of India.
If contempt is filed, you just convert. Notice returnable on second appraisal.
Twenty-six is adjourned. Silamba 27. It's a Shiv Prasad Chandragowda. It's a Shiv Prasad Chandragowda.
Lord, the mandatory issuance of life certificate for release of pension was called into question before the learned single judge. That came to be dismissed on the ground that, my lord, it is mandatory in nature. Even though, my lord, that such nature was not incorporated in the regulation, agreed by which, my lord, before this honorable court. Kindly see, my lord, the regulations governing the State Bank of India employees, insofar as pensioners are concerned, is at Annexure A. The relevant portion, my lord, wherein the pension will be granted to the pensioners is at page number 71, regulation number 52. The learned single judge, my lord, by page 26, para 7, came to a conclusion that, my lord, in case the pension is stopped, if the life certificate is not given, then it is the duty of the bank to issue notice. There is an exception carved out, my lord, by the learned single. But now, my lord, here is a case that many of the pensioners, my lord, are above the age of 70, 80, and many of them have, most of them are bedridden also. In that case, my lord, asking them to come to bank and give a life certificate, that may not be possible. Let there be a direction to the bank to issue notice to the pensioners. And thereafter, my lord, the pension may be stopped. Page 71, my lord, of the pension regulations may kindly be.
What is life certificate? Life of that certificate you are living.
To show that the person is living.
Every year, they have to give one life certificate for disbursement of the pension.
To show
that prevailing in central
the
government.
person is living or not.
He is living or not.
Person has to come physically to bank and issue that certificate. It's a standardized format to show that the person is living. If only after receiving it physically, then they issue the pension for that one financial year. Now here is a case, my lord, in many cases, the pensioners are above 70, above 80, many of them are bedridden, some of them are unfortunately are in old age home. In that situation, my lord, stopping the pension abruptly at the end of, at the beginning of April 1st would cause undue hindrance to the petitioners in concern. Keeping that in mind, let the bank issue notice to the pensioners because ultimately they were working for the bank. They were earlier SBI employees. Let them issue notice prior to stoppage of pension. That is all we are asking before this honorable court. Because learned single judge holds that in para 7, they say it is mandatory in nature, even though, my lord, the regulations stipulate that there is no such mandatory in nature. The pension can be stopped only on the
division bench order is relied on.
Yes, my lord.
Or coordinate bench.
Please,
what is that order?
The coordinate bench order, my lord, there was a case when the concerned petitioner was 101 years old. His pension came to be stopped. Agreed by which, my lord, he approached the learned single judge. Learned single judge ordered that in cases of people who are above 70 or 80 or 90, let there not be stoppage of pension immediately. Let the bank issue notice and thereafter there is a reply or not, then the pension can stop. Abruptly, one cannot be stopped. Following that, my lord, this order came to be passed by the learned single judge.
So this certificate is required to be issued every year?
Every year.
Every year.
Yeah. Now, kindly see the regulation. I'll just take your lordship to the
every year is reasonable. What is wrong?
Yes, ma'am. My lord, in this case, my lord, to prevent fraud, what happened, my lord, bank has got the experience. They will not inform that somebody will collect the money and all these things. Ultimately, come to know that after so many years that this person died. So to recover the money and all these things is a problem. That is number one.
A mechanism to identify.
Number two, my lord, wherever he is unable to come, bank officer will go to get the certificate from him. So this system is prevailing in other banks, including State Bank of India. If he says that I am unable to come, I am unable to move, I am aged, one bank officer will go and collect to verify whether that person is living or not.
Because many a times, my lord, the.
And this is going on for
pensioners-
several years, this is the
Yes.
first time it has come. All the banks, all national bank it is there,
Where is that?
government also it is there.
The observations in para 8 of the judgment
Yes.
safeguards your interest.
Yes, my lord.
Now, what happens, my lord, the registered address of the retirees may be changing time and again.
That's okay.
Keeping
See,
that in mind, my lord,
in the
let-
event the pensioner whose pension is suspended for want of life certificate,
And the
he can
moment
apply-
the entire amount will be paid on the
So
same
far
day.
as other banks are concerned, there is specific regulation insofar as life certificate is concerned. Now, insofar as SBI employees are concerned, kindly see on page number 66 of the appeal memo. There is only one ground wherein the pension can be stopped. There is no other ground. Kindly see at page number 66, regulation number 43. Withholding or withdrawal of pension. Page number 66, my lord. Regulation number 43, bottom portion. Withholding or withdrawal of pension. Before that, there is pension subject to future good conduct. Future good conduct shall be implied condition for every grant of pension and it's continuous under these regulations. Future good conduct, my lord, there is no definition of such, any of that. The next point, withholding or withdrawal of pension. The competent authority may by order in writing withhold or withdraw a pension or part thereof, whether permanently or for a specified period, if the pensioner is convicted of a serious crime or criminal breach of trust or forgery or acting fraudulent or is found
see,
guilty.
that is when he is alive, okay?
That is the only ground, my lord, wherein the pension can
No,
be
no,
withheld.
no. Withdrawal or withholding of
Withhold.
pension is on that ground. They are not telling they are going to withdraw your pension or withhold your pension.
If I don't get pension on the month of April, that is withholding. Now, only on the ground of issuance of
No, no, you are supposed to produce the certificate every November.
November,
Yes.
exactly, my lord, November.
if I don't
And it
make,
is published in circular and all, everybody is knowing, my lord. Otherwise,
if I don't,
That circular is issued by whom?
this,
banks,
That certificate is issued by whom?
the bank,
Life
certificate he has to give to the bank where he is drawing pension.
No, no,
Stating
life,
that
life certificate will be issued by whom?
it's a self-attestment.
self-attested, my
Yes,
lord.
number
He has to
10.
give.
Self-attested.
Self-
Ah, yes, I am living it. That's all. Nothing else, my lord.
Self-attestment, my lord, which one has to.
Then that much safeguard they deserve to. Otherwise, you don't know who will come in.
Liberty is given either personally or through association.
Hmm?
See, you can make a representation through association. also.
Association.
That liberty is also given.
Para 8, my lord, is very clear.
Yeah. Instead of you filing an
And
appeal.
you have everywhere your associate.
You did that.
So dismissed.
Great.
You.
Then what date? 18.
Twenty-eight is urgent. Seal number 29, to Basuraj. 29.
Delay of
appear for the respondent. Not, I have only one submission. Pending consideration of this appeal, the order of the learned single judge is given effect by the appellants. I don't know whether they want to pursue this or.
No, under the threat of contempt, we have issued the order, Lordship.
who has
That-
threatened you?
Contempt, the contempt proceedings was passed by this honorable court. So under the threat, we have complied the order, Your Honor. But that doesn't mean that the rights cannot be taken in this appeal, Your Lordship.
What is the effect of redesignation of post? Some emoluments are increased?
Not now, everything has been given effect.
No.
This notes.
What is given effect?
Not the orders of the learned single judge notes.
Correct. What
To
is the
redesignate a post notes from with effect from 8/11/2019 as.
post
as
is
per-
redesignated?
Yes.
So what is the effect of redesignation of post? Some amount you are getting more amount?
No, so we're not, that observation single judge has made, that benefit I will not get. Only that designation that I will have a
No,
benefit.
probationary period has been confirmed on in the year 24/4/2020, whereas single judge overlooked this and it has been affected from 8/11. Probationary period has been confirmed 24/4/2020, Lordship.
Hmm.
Kindly see, Lordship, page number 8, my grounds, Lordship. Karnataka Civil Service Provision Rules 1977, subclass 5 to 5 class surplus 2, Lordship. The petitioner shall not be considered to have satisfactorily completed the probation unless a specific order to that effect is passed. Any delay in the issue of an order under subrule 1 shall not entitle the probationer to be deemed to have satisfactorily completed his probation. So now it has been confirmed. Annexure A, Lordship. Annexure A, page 30. Probationary period has been confirmed on 24/4/2020, Lordship.
May I make this mention? If my friend is pursuing the appeal, there is a delay, my lords. I want to file objection. I want to oppose it seriously.
Delay is there.
216 days delay.
216 days, there is delay, Lordship.
I will file objections, my lords, if he's
24th March. Yes, learned respondent wants to file counter to the delay condonation application.
Issue number 30. Sharon N. Majige.
The plan. Yes, that the learned single judge has directed the housing board to consider the petitioner's representation for promotion and also to place the petitioner papers for regular promotion before the DPC. Now, as per the order of this, the learned single judge, the respondent has been promoted under Rule 32. But the only impediment coming in the way of the appellant board is, sir, the matter cannot be placed before the DPC unless we put it under sealed cover. So to that extent, the order has to be modified. Well, the apex court in Anil Kumar case has clearly held we don't mind considering his promotion. That has to be kept under sealed cover before the DPC, and it can be opened and can be relied upon only after discharge of the respondent from the criminal proceedings, after acquittal or discharge.
So second direction of learned single judge will not survive.
Yeah, but that cannot be considered because
We have to modify.
the criminal proceedings are pending, and now at this stage it cannot be considered. Now, that's what the apex court in Anil Kumar case has held.
My
So
lords,
you are facing some inquiry?
I appear for respondents. The writ petition order was directing the respondent to consider the petitioner's representation for promotion. There was no denial as such. There was only a representation which was not considered. It was supposed to be considered.
It has been considered and he has
He's
been promoted.
my lords. Because the ground which is urged by us before the learned single judge is that pendency of criminal proceedings does not justify the denial of promotion. That is the as laid down in Union of India versus KV Janaki Raman, and subsequently Union of India versus Anil Kumar Sarkar. Pendency of criminal proceedings cannot be a reason for denial of promotion. This is the ground that we urged, and subsequently we have been promoted. Our representation is considered. We have been promoted. He's reported to the duty, my lords, presently.
That's what the same judgment Mr. Infant is referring, Anil Kumar case, in which the apex court has said a government servant who is recommended for promotion of departmental promotion committee, but in whose case any of the circumstances mentioned in para 2 above arise after recommendations of DPC are received, but where he is actually promoted, he will be considered as if his case had been placed in the sealed cover by the DPC. He shall not be promoted until the conclusion of the disciplinary case, criminal proceedings, and the provisions contained in this letter will be applicable in that case also.
You are already promoted.
He's promoted there's, if
Under
there
Rule
is
32.
issue regarding the promotion or the way it was done, a fresh cause of action arises, not from the writ petition order. This is merely to consider the representation of the petitioner which was considered. There's no other order passed directing to promote the petitioner.
So
The
why
later part of the order may come
why
by
this final direction that petition will be required to file a fresh representative? Why?
My lords.
The last 3 lines and
Yes.
page 29, the petition and the petitioner shall be at liberty to file a fresh representative. Why?
In case if it is denied.
Reject.
My only apprehension is,
Right, nothing, there is nothing except directing to consider the.
Lord, to place the petitioner papers for regular promotion in the ensuing DPC. This is the direct.
Grant of promotion.
So that direction cannot be complied for the reason that the criminal proceedings are still pending.
If you are so of the view, then say no to the representative.
That's
Then
that's
where
the
is
reason in the apex court in Anil Kumar case,
That is
it
not-
can be kept under sealed cover.
Whatever
So
you want
that to
do,
that extent, the order may be modified.
where should we modify?
Please,
Do accordingly, whatever you feel in accordance with law, do it. Either
Will-
reject or
we will
grant
do it.
or sealed cover.
let this be observed, my Lord, based on the ruling of
Observed by learned
Anil
single.
Kumar's case, we will consider.
Unnecessary, we are not expanding the consideration of the subject matter.
Lord, this
We
is
are
coming
confined
in
to
the way because
We'll confine
to
ourselves.
place the petitioner's paper for regular promotion in the DPC.
Consider, allow directing this one to consider.
And there are so many other people who are in the similar circumstance. That is, it will, the difficulty is it will open the Pandora box. So many people will rush before this honorable. In fact, seniors to the respondent are also facing the criminal proceedings and their cases have not been considered. His seniority is at 27 and there are so many people above him.
This writ appeal is directed against judgment and order of Learned Single Judge dated 27th June 24, wherein Learned Single Judge has issued the following operative directions. Quote page 28, regulated portion A and B, full stop. Learned Senior Advocate Mr. Swanshaw, the appellant, would submit that the directions are not justified in as much as according to the petitioner, the procedure to be adopted would be to keep the decision in respect of the to keep the case of the petition for promotion in a sealed cover. On the other hand, learned advocates Ms. So-and-so stated that the directions are only to consider the representation and does not and that does not require an interference by this court in the appellate jurisdiction. Full stop. On going through the order of learned single judge, it could be seen that learned single judge has reasoned that the tendency of the criminal proceedings cannot be reason denial of promotion. Full stop. In the present case, it appears that the department proceedings have already culminated in favor of the employee. Full stop. Apart from the above, comma, as could be seen from the operative language of the direction, comma, the direction is only to consider in our comma. to consider the representation of petitioner for the purpose of considering his case for promotion. It is further required that the petition shall be communicated with the decision on promotion. Full stop. Since the matter is left to the respondent's authorities to consider the case of the promotion, comma, no case is made out for any interference in the said direction. As observed by learned single judge, comma, the case of the petitioner may be considered as directed by the authorities.
In accordance with law, it may be observed that his case would be considered in accordance with law.
It goes without saying that the representation
Let-
is
let-
considered in accordance with law and on its own. Appeal is dismissed.
Much obliged.
Number 31, which is Sumana Nagaran.
For the appellant's lord,
Delay of 77.
77 days delay is there, lord. There's an IA for condemnation. I appeal for the first respondent, lord.
They appear for the first. And who is for,
The main contesting
the
respondent
first
is number
respondent.
1, my lord. Others are formal because they were co-respondents.
who is their name?
Manmohan, lord. I appeal for the
Manmohan,
first respondent.
And 2, 3 and 4 government will appear.
I'm appearing for respondent number
Who is
3, my
for-
lord.
Who is
I'm
for
for
number
3.
2? 2.
1 and 2.
No, 2 no even shareholder.
Madam,
Lord,
two-
2 is lord, this shareholder of first
Shareholder, lord, of
respondent.
the-
I think
For
my
unit-
learned friend
Even
will
I'll
probably
take
appear.
notice, lord, for.
For number 4 and 5.
I appeal for respondent number 5.
5. What is your name? What's your good name? So and so. And number 4. So all are appearing.
Lord, can I seek some accommodation?
Delay
lord,
may
to
be
file
condoned.
my,
Delay may be.
Please.
Can I seek some accommodation to file objections? to
IA
the-
20 IA 2 of 24, this application is filed. For condoning of delay of
Right, ಇಲ್ಲ ಹಾಕಕ್ಕೆ.
77 days, which has taken place in preparing the appeal.
Page 237, my lord, is the explanation.
Lord,
At 239.
R1 and 2. Lord, can I make one submission, Lord? Lord, delay, Lord, with regard to delay, Lord, only one submission, Lord. The appeal is not filed by not a nodal agency, not by not an aggrieved person at all. Lord, the amount that has to be paid to me, Lord, is not by the BESCOMs or the ESCOMs. The appeal, Lord, is filed not by a nodal agency. In fact, the order that is quashed, Lord, is that of the state government under section 11. Therefore, Lord, or formally, Lord, I'll file the objections to that application for condemnation if my lords permit.
They didn't make, the actual persons were not made respondents in the case. Now, my lord, this point
Lord,
is raised.
What
If
happens
according-
is, the order that is quashed, Lord, is of the state government. State government, Lord, passed an order under section 11. But the appeal is filed, Lord, by SLDC, which is a nodal agency, Lord, only.
You want to file reply to the delay condonation?
I,
But all points you are raising is are on merits.
very well, I'll leave it at that. I'll leave it at that.
So explaining the passage of time leading to delay to the extent of 7 days, it is stated in the accompanying affidavit that after the judgment and order of learned single judge was delivered on 23/7/24, certified copy was applied for. So legal opinion was sought and further course of action was decided. Also, it was further stated that at various levels of hierarchy of the appellant government, the decision-making process traveled, and finally the decision was taken to refer the appeal. Full stop. The paragraph. The applicant appellant is a state Lord Dispatch Center, which is an impersonal body. Full since it is a company, consumption of time to some extent before the final decision could be reached, could be said to be inherent, viewed from this standpoint. And since the delay is attributable to administrative reasons and the consideration of the levels at the various levels of the appellate company, sufficient cause is made out, delay of 77 days condoned, application is
Lord, there's a direction for me to refund some money, my lord, that may be stayed, my lord.
Direction, my lord, is to the ESCOMs.
But now we are not hearing the appeal.
Please, but I'll file my objections to that application.
We'll keep it on 10th of March.
Grateful.
Appeal to be listed on 10th of March.
Please.
It's number 32.
Serial number 32, my lord. I appear for the counsel representing respondent number 3, my lord.
For the appellant, please, your lordship.
I may be permitted to submit a few lines with regard to respondent number 3, my lord. Respondent number 3 is a student of veterinary science and because of he has filed writ
The
in the
appellant, your lordship, the appeal is to the limited extent of the order directing us to carry out revaluation of the papers and keep the answer, the
lord.
results in a sealed cover. Now, that was the limited extent. Now, the petition filed by the
If
third
your
respondent.
lordship may permit me a few lines with regard to the respondent number 3, my lord. The
Either I submit or my
And-
learned friend submits, both of us can be doing it. Lordship may kindly see, revaluation is not permitted under the R regulations. Therefore, we follow the Veterinary Council of India regulations. Veterinary Council was impleaded and they've been directed to file their objections. Your Lordship was pleased to stay the order only in respect of revaluation and directed the matter to be heard on merits. They have taken time to file their objections before the learned single judge. The Veterinary Council, once they file their objections, the matter will be heard. That is understood by your Lordship's order. And that is all that remains. That nothing else remains. If this order is affirmed that till the disposal of the petition, no revaluation will be done, this appeal can be disposed of. And the matter will be heard by the learned single judge.
This appeal itself is not maintainable, my lord, because a discretionary order passed by the learned single judge is not appealable. There is a judgment from the division bench of Kerala High Court, my lord, that my colleague is with that judgment. If your lordship may permit me, I'll place before your lordship, my lord, because this appeal itself is not maintainable, because it's a discretionary order for revaluation has been passed by the learned single judge. And my lord, my almost 2 years now, my fellow students, they have been now in internship, my lord, because of the negligence, because of the carelessness, evaluation of
Which judgment you are relying on?
my colleague is placing before your lordship, if your lordship permit me, my lord. That Kerala Division Bench High Court judgment, my lord. It's a discretionary order, my lord. That cannot be questioned by filing a writ appeal, my lord.
Discretion is exercised where there is no provision for revaluation.
Please,
My lord,
Discretion is exercised by learned single judge where there is no provision of revaluation, to direct revaluation. That's the point.
evaluation, my lord, that
That's
itself,
the kind of finality, wrapping of finality.
no, evaluate.
Some right is created, some obligation is finally created,
correct,
irrespective of outcome of the petition.
absolutely.
That is how it was entertained.
And your Lordship may kindly see, the earlier round, she had filed an earlier round of petition. The order is, I produced that order at 131, wherein she gave up the relief of revaluation. And the Honorable Court has recorded it. She said, I just want to see my answer script. And the answer scripts, thereafter, your Lordship, answer scripts were produced in the court. His Lordship was pleased to say, note that every answer had been marked and that there was nothing wrong with it. However, she said then perhaps
I may be permitted
the
to.
invigilators were not up to the mark.
They are saying that this is interim order, it can be upset at the final stage.
Yes, please, your Lordship.
That is what they are saying.
No, that cannot be done, your Lordship, for the simple reason. Therefore, I'll take your Lordship to the order at page 131. And this is like granting the final relief. Then nothing remains. The final relief is revaluation.
It is 131.
131 is the earlier round of petition, your Lordship.
My lord, in the writ petition,
Yeah,
lord, I
I
was
wish my
permitted
learned friend
to
would wait for me to complete.
inspect my answer script,
Your Lordship,
lord.
may
In the
kindly see
answer
the,
script,
prayers of-
31.3 marks have been not given. 33.5 marks has not been given.
Your Lordship,
I
may
was
kindly
permitted
read
to
page
inspect. I
132.
inspected.
Now,
33.5
the
marks have
petition
not
is
been
filed-
given. Later on, revaluation was permitted, that is as a discretionary order.
My learned friend should wait till I finish.
That
Yeah.
is how this was also referred to in the order.
Please, your lordship has referred to everything, all of this and that. The prayer was given up.
But
Thereafter-
we have to consider this, this Kerala High Court judgment. We'll consider it, heard learned advocate. Miss,
Vaishali Hegde.
this is what's 32. Vaishali Hegde for the appellant. Learned additional government advocate, Harish for
Respondent number 1.
number 1 and learned senior advocate appearing through video conferencing, assisted by learned advocate Miss, what is her good name? Who physically appeared in the court. From outline, resolved for orders.
Number 33, the Sunil Kumar H.
This is a case in which, Lord, the petitioner has filed this petition seeking for repair of a public road in a taluk in Uttar Kannada district. Lord, in the earlier round of litigation which was pending before this honorable court, Lord, the learned advocate, additional advocate general made a submission that 46 lakhs is released for the repair of this road, which connects 3 taluks, my lord, Elapur, Ankula and Sirsi in Uttar Kannada district. Even thereafter, my lord, the road is in such a bad condition that the KSRTC has stopped operating the entire buses. Now the villagers and even they are facing it very difficult even to visit hospitals. The farmers cannot carry their produce to the lands. Hence, my lord, only limited prayer that the petitioner is seeking is to repair the public road, my lord, so that will be useful for all the villagers and the farmers.
My lord,
And you see the earlier order, which is in page 21. Page 21. And the relevant portion, lordship may kindly see at page 24, my lord. The first paragraph says, my lord, this is learned additional.
21 is your representation.
My lord, 24, my lord.
24.
Please, my lord. Lordship may kindly see 24.
Yes. This amount is not spent or spent, what is your?
Only minor repairs were made on that, my lord, because the road stretches about 23 kilometers from place called Bullapura to Kamani. And even the CEO of the village, the Panchayat also, my lord, he requested that a sum of rupees 2 crores is required. My lordship will find that at page 28 is the letter that he has written. The CEO of the Jilla Panchayat, the relevant portion, lord, page 32, lordship will find it page 32 translation copy. And in 33, hence with the reference so and so, my lord, he says already 48 lakhs has already been released. Further, with the release of the Panchayat fund, the complete repair and putting thar on the road is not possible to the said road. It's about 23 kilometers long, and keeping in mind the guidelines of the Pradhan Mantri Gram Sadak Yojana, the road has to be completely repaired, and for the further maintenance of 5 years and to refurnish at 6th year, a total sum of rupees 2,560 lakhs is required. The executive engineer Karwar has prepared a
Learned
blueprint.
advocate Mr. Sorens, the petitioner.
My lord, I appear for the respondent. In this case, my lord, this prayer,
Which respondent?
the CEO of Jilla Panchayat, my lord. We have filed a statement of objection stating that, my lord, government has sanctioned 48 lakhs. We have improved the road. And for remaining, we have sent the estimate to the state government, 7 crores and all, my lord. There is a direction by this court to, my lord, in the meanwhile, my lord, what has happened, my lord?
You are
This,
for number 1 here.
Yes, my lord.
my lord, in the meanwhile, this rural road has handed out to the PWD, and PWD has repaired the road, my lord. That to that aspect, I have recently our executive engineer sent a letter to us because 24 kilometer stretch, my lord, 10 kilometer has PWD has already been developed, and another 4 kilometers KRD had done it. and remaining road has been in good condition, and the officers also present. And I think, my lord, now it is, prayer does not sort of a consideration.
No, my lord. Even today, my instructions are that I'll go through this and I'll make a small submission with the lordship with regard to the photographs of the actual situation, my lord.
My
It
lord,
is
head
still,
of
the
that
lot of
PWD
potholes are still
department,
there.
engineer,
My lord, if they are
executive present.
completed and if the actual status of the photographs are produced before lordship, I'll not press the petition at all, my lord. My only concern is a public interest litigation where it is in the larger interest that they're seeking repair of the potholes. That is there. And my lord, petition is from 2018. They're only saying that they're only making small repairs.
Now entire stretch of the road has been handed over to the PW and, yes, ma'am. It is in Kannada, I translated mail. Page number 4 may be kind of translated in page 4, my lord, further. Further, as per reference number 3.
But in page number 4, they say the chain of road length from 14 to 24 kilometers, which were earlier constructed by the Karnataka Rural Development Authority, is under maintenance. They still accept that they're still under maintenance.
Or learned advocate so and so for the petitioner, or learned additional law. Correspondent one, and learned
R2, my lord, Ashok Kennai.
Ashok.
R2, Jilla Panchayat. Ashok
So and so, senior advocate. In the present petition filed under Article 226 of the Constitution, styling it as public interest petition, to petitioners who is a resident of the Ankola Taluka, Uttarakhand district, has advanced a prayer to direct the respondent to consider the representation to take 24/12/18 and to declare the public road work between Gullapura to Malavalli of Ankola Taluka, Uttarakhand. The grievance of the petitioner is that the public road from Gullapura to Pommani of Loka Taluka falls under the jurisdiction of Dongri Gram Panchayat. Petitioner wants the road to be asphalted for the use of public of Dongri village and surrounding areas. It is stated that the government has sanctioned a sum of rupees 48,25,000 for asphalt road in question. However, the road is still in bad condition, full stop. At the outset, it is to be noticed that it is to be observed that so the authorities are under obligation to upkeep and maintain the good road and the conditions of the road for smooth movement of the pedestrian and vehicular traffic, repair of road, extension or alignment of road, or such aspects cannot be subject matter of public interest petition inasmuch as these questions entirely fall within the domain of executive. Full stop. Nevertheless, noticing the affidavit in response filed by respondent 2, it is stated that the estimated cost of rupees 48.22 lakhs has been sanctioned in the month of November. And immediately thereafter, the tender was invited for repair work of the road. And the contractor has completed the repairing and recarpeting of work of the road from Matti, Matti Gatta, Kamani to Alavali Road into 5 kilometers as per the tender agreement. It is further stated that accordingly it is stated that the respondents have already asphalted 5 kilometers of road of the above stretch. It is also stated that further that the estimation was prepared and is submitted for repairing the entire stretch of 23.23 kilometers. In that view, since the authorities have already taken steps in the direction of repairing and upkeeping the road, so the petition has no merit. It is contended. Furthermore, in course of the hearing today, learned advocate, Learned Senior Advocate for this one too, submitted memo dated 18/24/25, producing along with communication from the office of Assistant Executive Engineer, Panchayat Raj Engineering Subdivision, Ankola, addressed to the Chief Executive Engineer, Jilla Panchayat Karwar. It deals with the subject of releasing the funds for repair of the road from Gullapura, Panamanni in Dongari village. Full stop. In the said communication, the estimation of expenses for reconstruction of the road is indicated, and it is stated that the said estimation is sent to the state government so that the work could be immediately started. Full stop. It is further stated that the road from Gullapura Kamani comes under the jurisdiction of Dongari Panchayat of Ankola Taluka, which has been upgraded from rural road to district main road in the year 2020 and is handed over to the Public Works Department, which has formed concrete road from the chain 0.00 to 10 kilometers in the year 2020. Next part, it is stated that next part of the road from chain 10.00 kilometer to 14 kilometer of the stretch of 4 kilometer in total has been reconstructed to concrete road in the year 23-24 by the Karnataka Rural Road Development Authority. Full stop. It is next stated that the chain of road for further length from 14 kilometer to 14.00 kilometer to 24.00 kilometer, which was earlier constructed by the Karnataka Rural Road Development Agency, is now being maintained. Full stop. In that view, it is clear that the authorities have been taking care to upkeep and maintain the road. No case is made out for passing any further orders in this public interest petition. It is accordingly not entertained. Please, next.
Still number 34, Rajesh G. Bhatt.
Impleading the applicant. Response 6 is my father, my lord. His application was pending for grant of Malayalam.
After a long time you are come.
Yes.
What is this?
Impleading application. Sixth respondent was my father, my lord. He had filed an application for quarrying lease. It was granted. That was questioned. Under Rule 25, I am entitled to come on record, my lord, as an LR.
My lords, I may be permitted to file objections with respect.
Not file. It's appeal. Let's petition.
25.
At the request of learned advocate, so and so, in order to enable him to file objections, 26th March.
2012 application, my lord, little early my.
Grateful.
Next week, no?
Number 35.
Next.
March 26. Earlier you won. Earlier will be difficult. 17th March.
In this case, my lord, I'm
35.
appearing. Sorry. I'm appearing for petitioner.
Pardon?
I'm appearing for petitioners, my lord. Here, my lord, the quarry list which is a crusher license which is granted is, my lord, the petitioner's village. Without following, my lord, the provisions under section 6 of Stone Crusher Act 2011. Therefore, my lord, the villagers who has been affected by, my lord, this crusher have approached this honorable court. Earlier occasion, my lord, the petitioners have approached by filing writ petition before this court. And my lord, this honorable, during the pendency of, my lord, the writ petition that they have issued an endorsement on the representation, my lord, kindly turn in page number 121 annexed. These villagers have approached and that they have said, my lord, that by virtue of grant of quarries in the residential area that they have affected, and, my lord, that they cannot, my lord, lead peaceful life because of dust and the traffic and road, all these things that they have narrated because they are using the road which is existed in the village itself. Kindly see there afterwards, my lord, the endorsement has been issued. That is in page number 127, dated 22/11/2023. In the said endorsement that they categorically they have, my lord, stated that this is within 190 meters from the applied residential layout. That is in page number 132, translated copy. The distance, can I read, my lord, 132, my lord?
My lord, it's covered by
I
my
have
lord's
maintained safe
decision, my
distance and, you know, what is?
My lord, it's covered by my lord's
Yes,
decision.
I'll make submission, my lord, that kindly see in page number 132. That I've, and in the distance of 190 meters applied area, residential layout in 437 meters distance from JC Palya residential area is found. This is, my lord, admittedly that they have given. I'll draw your lordship's attention because these villagers, my lord, have made all efforts by approaching Tahsildar, Assistant Commissioner, Deputy Commissioners, Police, SP, everything representation that I'll bring your lordship's notice. Before that, my lord, kindly see the in page number 640 Karnataka Stone Crusher Act. Section 6, my lord, specifies section 6 of Karnataka Stone Crusher Act, which is, my lord, reproduced in the writ petition provided. This is safer zone has not been declared in this area by the Deputy Commissioner. Apart from that, my lord, that's page 640, my lord. 640.
So appeal is available.
Please, my lord.
We'll follow our order.
This is, my lord, since, my lord, this appeal is under 53, if, my lord, that I have to approach to seek, my lord, this is, my lord, I am not the parties. The villagers have approached before this honorable court that they have affected by virtue of this. I'll make submission on that. Kindly see
Section 15 of the Crusher Act. Crusher Act?
Yes, my lord.
Section 6, my kind.
My lord, and my lord's
I'll-
order is that annexure R.
No, I'll make submission on provisions. The conditions for declaration of show declare that safer zone for the stone crusher under this act shall be subject to following conditions: 200 meters from the limit of national highway or state highway, 100 meters from the limit of major district roads, and 50 meters from the limits of the other roads, 500 meters from revenue village temple school. This is applicable because admittedly in the endorsement at ink page number 132 that they have said from 190 meters from the village and, my lord, 437 meters from the JC Palya residential area. Under those circumstances, my lord, which this is by virtue of grant of crusher lease in the middle of the village, they have affected, my lord, they have approached, my lord, the various authorities by giving representation starts from 56, my lord, Deputy Commissioner, and my lord, Mines and Geology Department, everyone that they have given. They have no any grievance, revenge against those people who are running. But my lord, that they can't lead life peace. They are, my lord, that is the colony-like area which they have granted, but they have not followed Section 6. Therefore, my lord, we have sought for, my lord, cancellation of, my lord, crusher license which is granted. According to the endorsement which is issued by respondent itself, shows that is not confined under Section 6 of the Stone Crusher Act. Therefore, my respectful submission is that, my lord, I cannot file writ petition because I am affected in this. Therefore, PIL has not been filed because we have given our address. We are the villagers. Therefore, my lord, public interest litigation has not been filed because we have given representation approached and it is affecting our
You
residents.
file your reply on merits. also.
My lord, I filed, my
On
lord.
merits also.
Yes, yes.
Let them file affidavit before this.
Which is the contesting? Those who are. Who appears for the private party?
My lord,
Private party, my lord, they have, the notice has been issued. But my lord,
Mr. Surya Mukundraj L.
my lord, notice is not issued, I think, my lord.
yes,
Otherwise
notice
it-
has been issued.
Surya
Not-
Mukund.
Notice you.
Notice issued.
I'm sorry, my lord. Surya Mukundar.
What do you feel? Loan advocate, Mr. Surya.
Mr. Surya Mukundraj L.
Surya Mukundaraj M appears for the private is phone number 5.
6.
Six, my lord.
6. Who is a contesting party against whom the relief is sought for in the present petition. However, learned advocate is absent. Full stop. In order to give him a chance to appear and contest his case, we must stand over to 27th February.
Please. But
Number 36.
yes,
My lord, in this, I'm filing an additional statement of objections. I have served a copy on my learned friend also, my lord.
I have received the copy now. I have to file one counter for that. The fourth respondent has not filed any objections, my lord. Fifth respondent.
Learned addition, government advocate, in the law for expert. I'll share additional statement of objections which is taken on record. Mr. In view of that, the objections are filed and the copy is out today. Learned advocate, Mr.
Fifth respondent has to file the statement of objection because
Stand over to which date? 26th of March. In the meantime, the fourth respondent may consider filing his reply.
fifth respondent has not filed any objection because they are the tender
Lord, I
holders.
am only implementing agency, my lord, which is, my lord, the government who is,
You
my
can
lord, the
consider
author.
your filing. reply. If you
Please,
want
my
to
lord.
file, you file. Otherwise,
Yes.
next. Charlie.
Number 37.
It's gone to where?
Anupama G. Abba.
When?
This is that Kambala matter.
My lord, if my learned friend wants to start, all right, but learned advocate general is on his legs in court all four, he will come. Otherwise, my lord may have it at 2:30 if it is convenient. 2:30.
2:30 is difficult today, my lord. I'm sorry.
Some
I have
other
some
day.
difficulty today.
We'll keep it on. Then let it go on 4th March.
Maybe.
Obliged.
Interim. I'm good.
Number 38. The case been
The impleading
petitioners in this case, my lord.
I have filed my application for impleading.
That Bane land.
Yes, Bane and Jumma land.
But my lands and my rights are questioned in this petition. I have not been made party. That's why I have come on
You filed.
filed application for
I
coming on
filed
record.
objection also, my lord. I filed my objection to my learned senior friend's application also. I have taken up the objection stating that, my lord, person who,
This will affect in his, on his land.
no, my lord,
My lord,
my lord,
certainly, my
I
lord,
am
my
not-
lands are, my Paradina lands are my lands. He questions that has to be removed from the revenue records.
no, that is important.
I should,
aspect
I
of
should
that.
make my submissions. I'm a necessary party. My rights are at stakes. Since 1800, my lord, lands are with us, and now they say it should be removed from the revenue.
My lord, the petition is here in a.
1899, 1825, 1877, 1886, regulations provide for that alienation. And we have come on record, we have owned the lands, now they want to take it away.
No, I
The
have
full
not sought
court,
for
full
that.
court of
pra-
this
I have
honorable
not
court,
sought
my
for
lord,
that prayer, my lord.
full court judgment explains
sir.
all that. If I come on record, I may make my statement on record, and then
Where is your application?
my application is one of 2024, my lord, filed on 27/9/2024.
One of? One of 24.
Yes, my lord.
So when shall we hear the petition? Today? We will be here, we'll give you audience. Consider it
Some other day, my lord.
in course of the hearing.
On merit, my lord. On merit or
When do you argue? Today or any other?
any date, minimum I required 1 hour time to.
Let me
want
come
the
on
matter
record.
on
I
merit,
may
my
make
lord.
a-
With regard to the impleading application is concerned, my lord, the petition here now filed this public interest litigation.
I am also a public, my lord. My
No, no,
properties
no,
are
no.
involved.
Let me, I am
And,
also having the.
Questions
land
my
with-
properties.
No, your lords may kindly appreciate. I filed petition here, filed this public interest litigation with a sentence, the slogan, save Kodagu from the timber mafias, my lord. I am not filed against
I am not,
any
I am
planters.
not on that
For the
aspect,
very
but
reason
prayer
that.
is- prayer
Let
is
me
that
complete, my lord.
to denude my rights.
No, no, no.
That's
That is
how
not,
I have-
that
I
is,
have
I have
to
not
answer
prayed,
that.
I have not prayed such a prayer, my lord. Only against the timber mafias and not against any planters and all. My lord, this, my public litigation is only based on the full court and division bench of this honorable court, my lord.
not apart from not even a single center or something.
We are
See,
also
my
relying
lord,
upon the same.
Paradina land, there is no concept of Paradina land in Coorg. There are various tenure in the Kodagu district.
We are arguing the matter.
No, my lord. Mana, with regard to the impleading application, my lord, and moreover, I have no objection to command record.
See,
by-
council, there is a government notification which states
Yes,
that if you are in illegal encroachment of government land in a plantation area
yes,
prior to 2005,
yes.
by paying 3,000 rupees per acre, if it is up to 25 acres, the land will be given to them. There is a government notification to that effect.
No, I am not
to-
on
up
that.
to
I am not on that,
1964.
my lord. I am not on that.
What I am trying to
Yes,
tell you
yes,
is,
yes,
see, forest lands are different,
yes,
but lands under cultivation,
yes,
unless you trim the trees,
yes.
that has to be carried out regularly. And they have regulation regarding what trees can be felled and what trees cannot
Also,
be felled.
No, that is, I agree for that. Natural trees grown on its own, natural trees.
Even
I am have
natural
the objection.
trees, depending upon the type of tree, certain
Yes.
trees, they won't give permission.
Yes, rosewood
For
trees.
done after obtaining the necessary permission.
Yes,
That is
yes, my
established
lord.
law.
That is what, I am not against, I am on the, based on the full court judgment and division bench
The
judgment.
prayer made by you is like
Omnibus.
court reaffirming the existing law. That's all, nothing else.
My lord, I have no objection to
1964 Land Revenue Act has come into
pleading
force.
application.
Prior to that,
command
1899
record.
regulations, my lord.
Their
That was
contention,
governing the
my
field.
lord, I will read the two sentences of my learned friend.
Why is the petitioner
Para 4, my lord.
fighting shy of the impleading applicant? I
No,
don't
I have-
understand because
No, that is what-
ultimately
my
my
lord.
lord has to
Can
give
place the
justice.
entire records.
My lord, there can be a quietus if the
Statement.
impleading applicant
my lord,
comes.
My learned senior friend has made a affidavit, filed affidavit of the impleading applicant setting. It is further respectfully submitted that the member of the proposed respondent being a planters plant the seeds and are instrumental in growing and nurturing the trees in their plantation, and thus interest is essentially involved in the adjudication of the above writ petition or essential necessary part in the. I have no objection to that.
When you start arguing the matter,
Yeah,
we'll
sorry,
consider
sorry.
their application also.
Please.
When do you want?
Any date convenient to this?
Tell the date and we'll keep on that.
Lord, I may be permitted to file a statement also.
Keep it ready.
Please, my lord.
We'll see whether you will be given audience at least.
Please, my lord.
20th March.
Much,
Obliged.
much.
Number 39, computation P.
The last occasion, my lord, the reply affidavits to be filed by the respondents with regard to the celebration of the Black Day on Rajyotsava by the respondent MES. They have to file.
time, my lord. We'll file our statement of objections.
My lord, for a minute, my lord may take the prayer. My lord, the petitioner may be, my lord, he may tell us to which portion he is confining himself to. My lord may see prayer number 2. My lord, writ of mandamus directing respondents 2 and 3 to prevent respondent number 5 from conducting or organizing any public demonstration, protest, rally or assembly on November 1st within Belgavi town or any other part of Karnataka. He has to make all the, my lord, the authorities as parties.
I will make, my lord. I will make that corrections.
What is this prayer?
This is especially for the Belgaum district only, man.
You are for whom?
R5, my lord. R5.
Who is that?
Maharashtra Ekikirana Samiti. Maharashtra Ekikirana Samiti. R5.
Come on, 2nd April.
Much brief.
Number 40, P. Vidulata.
I appear for the petitioner, my lords. The petitioner has challenged the validity of Rule 32 of the Karnataka Minor Mineral Concession Amendment Rules of 2016. There is a similar matter which is pending before your lords. That is WP number 10704 of 2022. I kindly request my lords to hear this matter along with the other matter.
It was stated that the
The
writ
earlier
petition number
10704 of 2022.
1000, 1000.
10704 of
10704 of
2022.
2022 is pending. Since it is, and it is stated that since it is cognate, the present this petition may also be directed to be placed and heard along with the said writ petition. The registry shall place both the petitions together on
The earlier matter, in the earlier matter, a date has not been given. Ma'am.
April. 9th April.
Obliged. Much obliged.
Cell number 41. Mr. Ramesh Chandra.
I appear for the petitioner, my lord. This for respondent number 5924, my lord. Paper publication has to be taken in Kannada proper, my lord. Notice has been served for 4 times, unserved, my lord.
9th of April.
I have filed for IA for paper publication, my lord. For in respect of 5924, my lord. Paper publication, my lord. For unserved respondent, my lord, 5924.
Who is not served? Who are not served?
5924, my lord. Respondent number.
15 and 20.
I filed the application to take paper publication, my lord.
15 and 24. For affairs. The endorsement is that Lord. There is no such person to the name.
Well, they are present, my lord.
Take hand delivery. Take hand delivery.
Handle. Okay. Yes, my lord.
So there is no swara affairs. So, number 15. One, two, three. Fourth. Respond number 15. Herein is for affairs. 30 E80 Street, Pasagundi, Bengaluru. Whereas this number 24 is Devsons, DEV, S1S Garments, Devsons Garments, 29 Police Station Road, Basavagundi, Bengaluru. Full stop. The notice was issued by this court to the respondents. However, in respect of the above two respondents, the endorsement is that no such persons exist of the name. Full stop. When the petition comes up for consideration, along with the application for paper publication from a learned advocate submitted that the said respondents very much exist, correct?
Yes, my lord.
At the place mentioned. Full stop in their view, there shall be press notice to the said respondent 15 and 24 returnable on 25th of March. Service by hand delivery is permitted.
This number 42,
But I appear for the complaint.
Madhusudan Rao.
That's, we
Permitted to
have
file
affidavit
rejoinder
is-
to the complaints, but what has happened is they have filed a complaints report. It is in fact not a complaint. The learned single judge had directed the respondents to issue Sagavali chit after being satisfied about the order of grant made in 1983. So what was to be given was only a Sagavali chit. What has happened is they have issued what is called as a fresh grant order, collecting demanding market value as on the present date, referring to the earlier grant order. Kindly see the complaints report.
The extent of land is 9 acres, including of
They
Kharab
could
land.
not have passed any
Your
such fresh order.
Sagavali chit is issued with a condition that they have to pay the market value as per the Act, land grant rules itself.
That
my
is
lord.
not the, what was directed to be given was only a Sagavali chit. Kindly see the complaints, this one, objection, your lordship may kindly see.
I don't
Complaints
have
report.
the, counter
The complaints
affidavit.
report clearly states,
Counter.
today I am filing the rejoinder.
I am ready, my lord.
And your lordship may kindly fix a short date.
Since rejoined affidavit.
Second round of.
Done at listening government at once time, send out. 8th April.
Number
8th April.
Serial number 43. To whom?
Lords, in this matter, my lords,
Sir,
we have filed our compliance affidavit initially, but the document had to be registered under part 3. My lords, the compliance
Who
affidavit.
appears? You are appearing.
to whom, Kar?
Madam, for the petitioner complaint in this matter. But this is pertaining to the non-compliance of the order passed in WP 10383 of 2024, my lord, wherein, my lord, the accused sub-registrar was directed to make the entry of the sales certificate that was executed in favor of the petitioner herein in book 1 and in all relevant records, my lord. But subsequently, my lord, an entry is made under Rule 17, Clause 2 and 3 instead of Rule 17, 17 Part 3A, my lord. Lord, the reasons assigned even in the compliance
Lords,
affidavit.
We had filed, let me make, my lords, the module is almost ready, my lords. We have run the module 2 days back. There are certain technical glitches, my lords. Lords may grant me some time. I've had instructions from the department. We will comply, maybe 4 weeks' time may be granted, my lords.
My only humble request is a date may be fixed, my lord, kindly.
25th of March.
Obliged.
I'm grateful.
Number 44, Mr. Arvind Jain.
We have complied, my lords. It was consideration of the representation. They want the conversion order to be cancelled. The remedy available is before the Karnataka Appellate Tribunal, my lords. Accordingly, endorsement has been.
Mr. Arvind Jain.
Learning single judge by order dated 20th June 2024 directed the respondent authority to consider the representation dated 2/4/24. The petitioner.
Lecture R5, it's page 22.
Within stipulated time. Also in response to the notice in this contempt petition by filing affidavit, it was pointed out by respondent deputy commissioner Bengal State. And that It was stated by producing. In response to the notice to this contempt petition, affidavit came to be filed by the respondent deputy commissioner of the urban district, along with which endorsement dated 12/12/24 was produced. Also, the deputy commissioner by the said endorsement has decided the representation, stating that the authority that the authority does not have the power to cancel the conversion order, and that the remedy for the appellant would lie before Karnataka Administrative Tribunal to prove his right and to seek appropriate compensation. Full stop. In view of the above, contempt petition would not survive. However, since learned advocate for the petitioner was not present, put up at 2:30 on 20th. To enable him to remain present. Yes, next.
Similar matter.
45?
Similar.
Same order,
Same order.
same order.
Number 46, Mr. Abhinav Raman.
In this matter, requires some time, my lords.
All waiting for the complainant.
3rd of April.
Obliged.
Lord, the last occasion, my lord, the learned government advocate had undertaken that they will comply with the order and also file an affidavit to that effect. My lord, if
So,
that submission may kindly be.
I'm not making that submission, my lords, my
Order
instructions.
is passed. Press affidavit to be filed, you file it.
Obliged.
Please, great.
Number 47.
Appear for the
Appear.
petitioner complainant.
Lords, in this matter, my lords, this is validation of caste certificate. My lords, competent authority has to be impleaded, who has to validate the caste certificate, my lords, that is Atalji Jana Sneha Kendra Director. Unless he is impleaded, my
The
lords, we
direction
can.
is something else, my lord.
Tahsildar
That is-
and
that is
AC
only-
has no
One
powers.
second, I will make my submission. The direction is that make available the caste certificate in the official portal. That's all the direction. There is no question of validation. Validation will have to be sought by either by the petitioners or the employing authority. There is no question of validation. Kindly look at the order passed by the learned single judge. For the last 2-3 months, my lord, they are not obeying the orders.
So the deputy commissioner can ask the
Lords-
subordinate to.
Lords, it is,
Instead, my
it
lord,
is
they are
altogether
taking
a
coercive
different,
steps.
it is altogether a different department, my lords, where the software is running. And this Atalji Jana Sneha Kendra Director is the competent authority. He has the control of that software, my lords,
A
unless he's.
learned additional government advocate, Mr. Pramodini Kishan, submits that for the purpose of implementing the direction given in the, issued in the order of learned single judge dated 29 February 24, which is with regard to uploading the caste certificate on the web portal and make it accessible to anyone, any other person holding caste certificate, a separate department is functional under the.
Lord, These are the authorities who are
Under the.
at
under
the local level, my lord. Even under
which-
the.
Under the revenue department.
Yes,
Under
please.
the revenue department. Full stop. This submission would hardly be countenance. Full stop. The direction is given to the deputy commissioner, who shall ensure that an officer is deputed by him in this very department, which deals with the uploading work, and the order is complied with before the next date. Put upon,
My lords,
no, nothing doing. 24th March at
because
2.
there are two separate orders, my lords. There are different directions. Therefore, I made the submissions. Your lordship may kindly see this order wherein the same parties are there. There is a direction to the deputy commissioner to conduct inquiry, and here there's a direction to
In respect of same party.
same parties, my lords, same parties.
So how come that the two different petitions were filed?
Therefore, that is why I made, because if they make a party, then we can make the submissions and file an affidavit, my lords.
There is no, I'm sorry, my lord. No such order.
No,
Your
The first
Lordship,
one
kindly
is,
see,
first one is
page,
22nd April 2019.
here what is the direction?
the direction, my
Same
lord,
day.
How come that
16426.
two petitions, the same subject came?
They have filed, my lords, the same parties, most of them. There are about
Kindly look at the first order.
No,
with
we'll
my-
not to get you explain why there are conflicting order by same.
26 people, my lords, they have filed the same
What
petition
had
two
happened
times.
was, not, the Tahsildar
See
issued,
that?
1 second. Ma'am. Tahsildar issued caste certificate. He himself cancelled it. Therefore, the petitioner came up before this honorable court. This honorable court said you have become functus officio. Therefore, you cannot pass any order. If at all any grievance is there, anybody will have to file an appeal under 4B.
So
That
they
is the
are
order.
aware of this order, my lords.
That is the order.
So
Kindly-
that inquiry is pending pursuant to this order.
Can they have you filed 4B appeal?
We are not concerned with this order,
Yes.
madam. You have to comply with this.
They don't file even objection statement.
Subsequent order.
My lords, this may be a subsequent, but there are two orders, my lords. One order says that there should be an inquiry conducted with respect to these caste certificates. And present order says that you validate the caste
In
certificate.
where is that inquiry conducting order?
My lords, this order, my lords, in 16426, it's the last page, page 12, my lords, liberty is reserved.
Liberty is reserved.
So pursuant to this, inquiry is being conducted. Liberty reserved in order so and so.
Liberty.
Needless to state, any person including respondent who may be aggrieved by issuance of caste certificate in favor of the petitioner shall be at liberty to file an appeal under section 4B and
No,
F of
page
the
12,
Act.
my lords, page 12. Liberty reserved in order dated so and so in
It is
jurisdiction
order
passed
dated-
by the court operates subject to its availability at its juncture. And your lordship may kindly see the order at page 6 of the next order. Needless to state that any person, including respondent number 1, who may be aggrieved by issuance of caste certificate in favor of the petitioner shall be at liberty to file an appeal under section 4B and F of the Act. So this proceedings is pending before the Deputy Commissioner, my lords.
2019, my lord, liberty is given. Now when contempt petition is filed, they force the deputy commissioner to take action in 2025.
Why you are not uploading the certificate? It has
Lords,
nothing to do with the appeal.
because they belong, because the inquiry is pending, my lords, and they belong to upper caste. This has wide repercussions, my lords. Then they'll get all the benefits such as job, education, and
Certificates are not cancelled.
everything.
Certificates are not cancelled. Inquiry is going on.
Inquiry is going.
Till it is concluded, you upload this certificate. Nothing more is required in this contempt.
We'll file our affidavit, my lord.
File an 24th March.
Obliged.
For the deputy commissioner, before deputy commissioner, day to day, they are posting the matter. Day to day.
So then.
Because it has wide repercussions, my lords.
Maybe you may be right to some extent, but then decide the appeal.
Obliged, my lords. Then there could be such a directions, my lords.
Why should we? give it?
Very well, my lords. We'll decide and we'll place it before
Sure.
the honorable court.
It might take care of the contempt also once you decide.
Obliged, my lords. We'll place it before the.
Number 48 to Malla Reddy BB.
This we have
Compliant.
complied, my lords. We have
Give court.
endorsement has been issued. Since today. It's in vernacular language.
But where are the directions?
My lords, what has happened, my lords, here now, as per the this endorsement, we have given approval for the road, my lords, that was deleted as per the 2015 revised master plan. It was there in 2007 CDP, my lords, it was deleted in 2015. Now we have restored, we've given approval for it. Provisional approval.
Oh, this is
Short accommodation, I will make submissions.
This is a,
Create difficulty.
but this is a provisional approval granted by the state under section 13(1) of the Karnataka Town and Country Planning Act. Well, after this.
You've reduced this with memo?
I'll produce it with memo,
Oh, that's.
with the
that's-
translated copy.
That's better. While learned additional government advocate states that the order is complied with and the order provisional
Approval.
approval is granted, comma, the order granting provisional approval may be produced on record along with memo. For this purpose and for the purpose of enabling learned advocate for the petition of Mr. So and so and so and so. Look into the matter, comma, stand over to day after tomorrow at 2:30.
Obliged.
But after the provisional approval is granted, sorry, there's a 60 days notification which has to be published. After that, my lord, the 13(3) final approval will be granted by the planning authority. This is how it is, my lord. Section 13(1) states that the provisional approval and subject notification and calling for objections from the general public with regard to the modifications. Then, my lord, a final approval will have to be granted. That is how it is.
Let us see.
Please.
Number 49, Mr. Satish K.
Appearing for complainant, my lords. They have not complied the order, my lords.
Let's
Order is
see.
at page 20, my lord. Annexure A. Matter pertains to compassionate appointment, my lords.
Lords, we have filed SLP, my lords, and we have obtained dairy number 900.
SLP is filed, comma, the request for granting time deserves to be accepted. Let the present contempt petition is listed next on 15th April.
Obliged.
Please.
Number 50,
Lords,
Complaint by me.
Vasant Kumar.
matter, my lords, I apologize, my lords. I kindly request for 2 weeks' time.
No, my
lords.
lord, I'm seriously objecting
I
for
shall
any adjournment,
ascertain-
my lord.
I shall
You
ascertain. as
kindly
to what-
see the order passed by the learned single judge, my lord. There is a direction to comply within a period of 4 weeks. Still, they have not complied, my lord.
In some matter, you appear and say that it is compliant.
Lords, today we have,
Instead of asking of time in every matter.
lords, today at 2:30, a matter is listed where we have.
Matter is
complied.
very simple, only to determine the value of the title as on
25th.
prevailing date of
25th March, as at the request of learned advocate Mr. Achan,
Chinmay for Vachan,
Chinmay
for Vachan,
for the respondent.
serial number 51, my lord, same order maybe.
So to
On the same date,
25th March
the
is too
connected
long,
matter.
my lord, subject.
Same order in 50.
Please.
Short date we may accommodate him on the,
25th March.
it's too long, my lord.
Too long.
Because there is a direction to comply within 4 weeks, my lord.
In every
The
matter.
order
there is
came
a
to pass in the 2014 August. Already 6 months is over. Subsequent amount has been given.
18th March.
I'm
Much
grateful,
only.
my lord.
Number 52, Mr. H. Maltesh.
Yes, no, the direction is to, to mutate the the name of the the complainants in the computer, the RTC. But the direction, the connected matter, last may kindly see, it's very clear. In the year 1998, land was granted. But till 2002, manual RTC was there, After that, name of the petition is not continued.
Yes, what is happening to representation?
Now the government has taken some decision to file the appeal, my lord. I request
What
some-
appeal in this matter?
No, there are around 70 matters, my lords, pertaining to the same, the forest matters, my lords.
No, no, we will not permit it. This is only directed to consider the same within the outer limit of 3 months. What is this? What appeal to be filed?
In the second matter, the next matter, the direction is
You
to.
cannot express any opinion on the merits of the, God says that.
Connected matters, my lords, till 56, my lords. From 52 to 60, all relating to
52.
the forest matters, my lords.
This is 52.
Please, my lords. All are till 56 also, my lords, all issues are the same, my lords, and there are other 70 matters also, my lords, pertaining to the same issue, my lords, the forest matter.
Yes, you, they are deciding the representation.
That some, now they are taking, to preferring to file a writ appeal, my lord, that is the, my lords, that is my
For
instruction,
what
my lords.
purpose?
Weeks time may be granted, my lords, with
No,
all
no.
these matters, my lords.
No, 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 no. You can't go on dragging this matter like this.
A lesser time, my
Any
lords.
substantive order is passed in any matter, which is
I second-
connected
in
to
the-
this, then we can understand.
Last kindly is in the next matter.
Keep it on 22 March.
Please, my lords, please. All 6 matters, my lords. All 6 matters. Please,
Is
my
it, does it pertain to the forest department claiming that it's a forest
the
land?
forest land, my lords.
And that the handwritten RTCs were manipulated and entries were made?
That is
No,
the-
no,
that is-
my lord.
no,
There
that
is
is-
a
that is-
grant
No,
order.
this is the contention of the state we are asking.
No, there is a grant order.
no, they
There is a
says-
grant order. I will till 2002, my lord, the manual RTC is there. No, we are cultivating the land. We are seeking for them not computer the RTC to enter our name in the RTC. But there is no, not to say that my lord, it's a government forest land. There is no any order, my lord.
Okay.
Up to 56.
Yes.
Up to 56.
Number 57. To P and Harish.
For complaint.
The accused.
Last time they have given a memo, my lord, stating that we have temporarily given connection to this. Because that is not in strict compliance of the order, because I would need to file a rejoinder to that. My lord, what has happened, it temporarily means it could be recalled at any time. My lord, I am only asking for a kata to be made in my name and NOC for our sanction. Oh, they have given him, last time they have given him endorsement, my lord, stating that it is temporarily, it has been ordered. My lord, the order of the learned single judge is very clear. It should be, kata should be maintained in my name till the disposal of the suit.
Can I take you to page 13, your lordships? In that it's clearly mentioned that whatever entries to be made will be subject to another suit which is already pending.
Yeah, that is okay, my lord.
In view of
is-
that, we've given them a temporary connection.
Connection for?
Khata entry within the registrar as well as NOC for getting electricity connection. We've given them that both as per the learned single judge's order, we've given them both on a temporary basis. Because in page 13, the learned single judge has clearly said that the entries is to be
Grant
made
it the same
subject.
terms. You grant it in the term, the subject to final outcome, the.
Yes.
Instead
That
of
is okay, my
temporary.
lord.
Okay, my lord. We will
Instead of
provide-
temporary in the same terms, so
Please, my lord. We'll provide that, my lord.
reissue that.
My lord, 1 week, my lord. Next week, anytime, we'll.
Please,
To be listed on 19th March at 2:30.
please.
Much obliged.
Either you want to, either you can issue fresh order or just put an affidavit.
Much obliged.
Please.
It will solve the problem. Yes.
Please.
Number 58, Ranganath S. Joyce. Number 58, Ranganath S. Joyce.
Pass on.
Number 59, Aditya Chatterjee.
For the complainant. My lords, in this matter, there is a compliance, my lords. Worship may have been more, my lords, we have already issued an endorsement, my lord. There is a compliance.
I think it's serial number 59. 59.
Lord, I'll file my objections and affidavit to the effect that the maintenance has been taken care of for the entire apartment complex. And we have spent about 1.17 crores, my lord. And I'll file an affidavit to that effect, that we have done the compliance, we have been doing the maintenance. My lord, this is an association which has been run from 2015, my lord. There are 400 apartments, and out of which 5 apartments belongs to the petitioners, the complainants herein. There are multiple proceedings pending, my lord. I will file my objections and an affidavit saying that we have done the compliance.
Which I will be able to demonstrate they haven't, but let the reply come.
15th April.
Number 60, Shilpa Rani.
Nobody is there.
The complaint in this case, my lord, they have filed the complaints affidavit, my lord, saying that they have transferred the work comes to my place, my lord, but there is no specific order that, my lord, they have taken me back to service, my lord. That order has not been placed in this case, my lord. After this contemplation draft, again they will terminate from the services, my lord. There is a specific order by this learned single judge, my lord, not to disturb my possession, my lord.
Where is that order?
My lords, may I make a submission, my lords?
Interim order.
Please, my lord, page number 12, my lord. Page number 12, my lord. May I read, my lord? It is stated that in similar writ petitions also, this court has directed that the petitioners therein who are similarly situated as the present petitioner should not be relieved from their respective post that they are holding in the institution till the next date of hearing. That interim order is extended till today, my lord. They have disturbed my possession, my lord. Later they have initiated be back to position. That order is not placed here, my lord.
My lords, similar to the matter my lordships had heard yesterday, this is in contempt proceedings that have initiated from an interim order. But not prejudice to that, my lords, we have complied with the learned single judge's order. There are 3 complainants before your lordship, my lords. In regards to complainant number 1, if I could peruse your lordships to annexure R3, my lords will find the translated copy on page number 14. Towards the end, my lords, as per reference number 1, am I reading with your lordships? As per reference number 1, outsourced staff Kiran M, First Division Assistant Co-Computer Operator, has been ordered to continue the vacant post of First Division Assistant Computer Co. As per the order, we tried to contact Kiran M by phone many times. He's not receiving calls, and I would like to inform you that no response has been received from him, and the said person has not attended the residential school duty, my lords. And in regards to the complainant number 2 and 3, my lords, they have already initiated duty. The staff attendance register has also been produced before your lordships as annexure R4 and R5, my lords. So the learned single judge's order, despite it being an interim order, my lords, we have complied with the same.
My lord, in this case, my lord, Kiran is tried many times in their office, my lord. Give me the order. They have given any oral, they are telling in the oral one, my lord. There is no writing order, my lord.
You go tomorrow and join the duty.
Please, my lord. They can give a writing order, my lord.
You are going tomorrow.
Please, my lord.
At what is the hours of duty?
I'll go and join, my lord. But their same principle says
So
there is no oral, there is no writing order. Hence, you bring the writing order. They'll come to hear, my lord, for the institution.
Where
They
are the-
seek for a writing order. They are not giving writing order.
1 second. Where is the direction?
My lords, direction, my lords will find an annexure A of the contempt petition, my lords. The interim order, page number 12, my learned friend had
It
read
is
this.
an interim order, right?
Please, my lords, it is an interim order before your lordship.
The order which is brought under the contempt jurisdiction is interim order. Nonetheless, when the since the notice is issued earlier, the court inquired about the status of the service of the petitioner's hearing. Full stop. There is a dispute about the aspect whether they have been in service or not. Learned advocate, for the petitioner submitted that the petitioners are not permitted to duty, nor any formal order of taking them back on duty.
There is no order has been passed by them, my lord.
So it is further stated, however, by learned advocate with petitioner that one petitioner, that the petitioners shall approach the which office? Which office? Where you are serving?
Second accused, my lord. First accused, my lord. First respondent, the institution.
Where is the, which institution? Approach the, where is that? Employer.
Yeah,
Respond number one,
petitioner is
respond
third
number one here,
institution.
there's Karnataka Residential Education Institution Society and shall report on duty day after tomorrow.
Please, my lord.
Day after tomorrow.
Please, my lords.
Full stop. It was stated in response by learned advocate Ms. So and so and so and so, but number one, that they'll be permitted on duty and will be allowed to work. Full stop. Send over to 18th of, send over to 11th March at 2:30.
Please, my lord.
Case number 61.
Appear for the commission. And I had filed a memo for deleting respondent number, accused number 1, 3, and 5, my lord. There is no direction from this court, my lord. Therefore, I had filed a memo. Lordship can kindly issue notice to the accused number 2, my lord, commissioner. There is a direction from this court, my lord. Page 12 of the order. Page. Para 12, my lord.
Where is the memo? Memo dated 13/11/24, which figures on record, is filed to request the court to delete respond number 1, 3, 4, and 5. As in view of the petitioner complainant, they are not necessary party. These respondents, namely number 1, 3, 4, and 5, are permitted to be deleted from the area of respondents at the cost and consequences of the petitioner. Full stop. Notice is not issued.
Not issued.
Notice shall go to the rest of the respondents returnable on 3rd April.
Wait for it. Cell number 62. So Raghunath MD.
Not there.
Appear for accused.
Number 62. So Raghunath MD.
Nobody is there. Keep back. No, write down in the serial number 74, 74.1, and 75. 4 weeks time is granted to remove the office objections, failing which the writ appeal, separate order, or the petition, whatever it may be, shall stand dismissed automatically without reference to our order. A similar order on 76, give 3 weeks. Who is appearing 62? Which objection is raised?
Lord, we have served the
On-
copies on the
Office
complaint,
of
my lord,
raised
on the last date of hearing itself. On that ground, he has taken adjournment.
counter affidavit.
Please.
16 filed by advocate accused. The office of this shall be removed within 2 weeks.
We have served, my
62.
lord. We have served. On that ground only, he has taken adjournment on the
Send
last
out
date of hearing.
24th of March. Next,
Cell number 63.
same order, 63.
Cell number 64.
For the
Yes.
appellant, my lord. Week's time,
Non-payment of court fee,
week's time may be granted, my lord. I'll cure the defects and I'll
same order.
maintainability.
weeks' time may be granted.
2 weeks.
Number 65, tertiary.
Await service of notice. Await service of notice, my lord. Await service of notice, my lord.
Alright. Services are at 60 already. To be listed after the service is complete.
Number 66,
Service is awaited, my lord.
Same order.
number 67, Mr. Prashant BR. There are office objections with maintainability.
Read up it.
Mr. Prashant BR.
So 3 here, so compliance of 9 of officers will be complied within 2 weeks failing which the appeal shall stand dismissed automatically without reference to or order of the court. Yes, next 68.
Number 68. Mr. Ganpati Bhatt.
For the respondent number 9, your lordship.
Same order.
Number 69. Lakshmama.
Reporting death in so and so, so and so. What is it? Correct address.
Steps to R.
Necessary steps shall be taken by petitioner for the learned advocate of the petition for supplying the correct address, etc. As per the endorsement, within 2 weeks failing which the writ petition shall stand dismissed automatically without reference to or order of the court. Next.
This number 70.
My lord,
Fully BS.
this I take notice for respondent number 2, my lord, who's the deputy commissioner.
Lord, I appear for the petitioner in this matter, my lord.
So what is it? Notice, your notice. Notice
Lord, I have
written,
to,
notice returnable on 16th April.
I will serve, my lord, a copy, my lord, upon the learned
Lord,
government.
statement has also been filed. Considering that, my lord, respondent, steps is to be taken for respondent number 2, my lord, who's the deputy commissioner revenue. My lord, I'll take notice.
I will serve, my lord, another set of copies, my lord, to the learned government.
Accepts notice on behalf of this one or two. Next.
Number 71.
Oblige, ma'am.
Appearing for the appellant, my lord.
Second set is 70.1. Second set shall be filed within 1 2 weeks. Another officer will be complied with. Within
My lord, in
same
seal number 71, I appear for the appellants.
filing with the petition shall up. Within unless within 2 weeks failing which same 71.
Number 71. For furnishing of process fee, etc. So Manoj K. Respect of respondent number 1.
So what is to be done here? 2 weeks is granted to comply with the objections, failing with same order.
Number 72. Steps for respondent number 3.
Same.
Number 73. Steps for respondent number 8.
Your lordship, appearing for
petitioner. Pardon?
appearing for respondent number 8, your lordship, seeking a small accommodation for filing wakalatnama.
11th March.
My lord, my lord, a similar matter is being heard, that is WP 206699 of 2022. A similar matter. It may be clubbed along with that, my lord.
It was stated by learned evidence appearing video conferencing that similar writ petition number 20699 of 22 is required to be listed. The said petition will be listed on 10/3/24/25. Yes. Not together, this one.
This for non-compliance of office objection for second time.
It is.
Number
order is
74.
Dictated, 75 dictated, 76 dictated, 77.
276. 77.
77, 70,
This
right?
objection counsel.
The office objection regarding limitation is dispensed with to be considered at the time of considering of the main contempt petition. Contempt petition may be listed on 21st of March.
78.
Same order, 28.
I appear for the complainant. It's a within the time.
Yeah.
And may be taken up along with the complaint number 147/2025, my lord. Date given is 19/3, my lord. Other connected matter was given 19/3, my lord.
Okay.
19th March. Grateful.
So we listed on 19th March. 79.
Both the matters.
79.
For the
Rajendra Kumar Shungai.
79 में the order हुआ.
Please.
79 में to be listed on 17. Now 80. Finally.
Final reading, number 80. To Sri Hari K.
Sri Hari cannot. Let it go to 1st April.
Number 81. To Shiv Kumar KB.
1st April.
Number 82. Mr. R.G. Kolle.
3rd April.
Number 83. To Narendra D.V. Gowda.
1st April. हो गए.
My lord, in list two, my lord, it is listed for office objections. My lord, in one matter, my lord, I have filed a translations. All are similar matters, my lord. The office objection may kindly be waived.
So 62, since translation is filed in other cognate matters, in the present, the office objection in that regard is dispensed.
Then, my lord, for the first respondent, B.C. Prabhakar is entered caveat. My lord, I have served a copy on that. Second respondent, my lord, learned government advocate may be directed to take notice, my lord. I have served copies on that. Matter is a small matter, my lord. Your lordship may have it next week and this
Petition will be listed on 24th of March.
25th, my lord. 24th. 25th, my lord.
Number 79, my lord, office objection has been compared, my lord, IA has been filed. And some urgency, my lord, 79, my lord.
79, what happens?
There is an IA.
79. What is the order? Whatever, what do you want?
Lord, short date, my lord, because it's at
Gives.
date in the ಕೊಡ್ತೀರಾ?
3rd March.
79 ಎಷ್ಟು?
3rd March.
3rd March.
Madam. Serial number 40.
Objection dispensed with similar matters are listed on 19th March. 22 March. 2 weeks peremptory order is 73 also 2 week peremptory order. 52 interim order.
75.
Till next date ಏನಿಲ್ವಲ್ಲ?
20, sir, 20.
Madam, 58.
20?
20 fast over in the
58.
20. ಕೇಳೋಣ. 62. 62 24th March ಹೋಗಿದೆ ಅದು 62. 2 weeks to remove office objection. 24th March ಹೋಗಿದೆ. 62 ಹೇಳಿದ್ವಲ್ಲ ಸರ್ 24th March office objection remove ಮಾಡಿ ಇಲ್ಲಾಂದ್ರೆ dismiss ಆಗುತ್ತೆ.
Second list 25 ಅಲ್ಲ? ಹೌದು.
ಸರ್ ಇನ್ನೊಂದ್ಸರಿ ಕೇಳಿ ಸರ್ ಅದ್ ಮ್ಯಾಟರ್ ನೀವು 62 ಅಂತ ಹೇಳ್ದಂಗೆ ಆಯ್ತು 62 ತಗೊಂಡ್ರು ಸಾಹೇಬ್ರು ಸರ್ ಬಟ್ ಸರ್
ಸೀರಿಯಲ್
ನಂಬರ್ 62 ಅಂತ ತಗೊಂಡಿದ್ದಾರೆ ಸಾಹೇಬ್ರು
ಅಲ್ಲ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್
ಹೇಳಿದ್ರಿ ನೀವು
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಂದ
ಹೇಳಿದ್ರಿ ಬಟ್ ಅವ್ರು ಹಂಗ್ ತಗೊಂಡಿಲ್ಲ 62 ಅಂತ ಹೇಳಿದ್ರು ನೀವು ಒಂದ್ಸರಿ ಮಧ್ಯಾಹ್ನ ಕನ್ಫರ್ಮ್ ಮಾಡ್ಕೊಳ್ಳಿ
2:30 ಬರ್ಬೇಕಾ?
ಹಾ ಮತ್ತೆ ಮಾಡ್ಕೊಳ್ಳಿ ಯಾಕಂದ್ರೆ ಇಷ್ಟು 2 ಇದೆ ಹಾಗೆ ಇದೆ ಅಂತ ತಿಳ್ಕೊಂಡಿದ್ದಾರೆ ಇನ್ನೊಂದು
ಓ ಸರಿ ಆಯ್ತು ಹಾಗಾದ್ರೆ 2:30
ಕೇಳಿ ಮಧ್ಯಾಹ್ನ ಒಂದ್ಸರಿ ಕೇಳ್ಬಿಡಿ
ಹಾಗಾದ್ರೆ 2:30 ಬರ್ತೇನೆ.
2:30 ಒಂದ್ಸರಿ ಹೇಳ್ಬಿಡಿ
ಓಕೆ ಸೀರಿಯಲ್ ನಂಬರ್
68 ಮೇಡಮ್ 68 2 weeks ಕಂಡೀಷನಲ್ ಮೇಡಮ್ ಇಲ್ಲ ಡಿಸ್ಮಿಸ್ ಆಗುತ್ತೆ ಎಲ್ಲ ಸೇಮ್ 2 weeks ಎಲ್ಲ
ಸೀರಿಯಲ್ ನಂಬರ್ 10 ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 10
ಇದೆ ಮೇಡಮ್
ಈಗ ಪಾಸ್ವರ್ಡ್ ಮ್ಯಾಟರ್ ಆದ್ಮೇಲೆ
2 weeks
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 10
44-45 ಕಾಲ್ ಮಾಡಿದಾಗ ಇರ್ಲಿಲ್ವಾ ನೀವು ಇರ್ಲಿಲ್ವಾ ಮತ್ತೆ 44-45 22
ಪಾಸ್ವರ್ಡ್ ಆದ್ಮೇಲೆ ಯಾವ್ದು
75 2 weeks ಪರ್ಮಿಟರಿ ಆರ್ಡರ್ ಡಿಸ್ಮಿಸ್
ಪಾಸ್ವರ್ಡ್ ಮ್ಯಾಟರ್ ಆದ್ಮೇಲೆ 230 ಮ್ಯಾಟರ್ ಕೇಳ್ತಾರೆ
2 weeks ಒಳಗೆ ಕಂಪ್ಲೇಂಟ್ ಆಫೀಸ್ ಆಫೀಸಿನ್ ಇದೆ ಅಲ್ವಾ 2 weeks ಒಳಗೆ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ ಇಲ್ಲಾಂದ್ರೆ ಡಿಸ್ಮಿಸ್ ಆಗುತ್ತೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಅದನ್ನ ಹೇಳ್ತಾರೆ
Court officer. Court officer. Court officer. Court officer.
ಹಲೋ ಹೇಳಿ ಮೇಡಮ್
ಸರ್ ಅದು ಅದೇ ಲಿಸ್ಟ್ ನಂಬರ್ 3 ಸೀರಿಯಲ್ ನಂಬರ್ ಅದೇ ಐಆರ್ ಮ್ಯಾಟರ್ಸ್ ಕನೆಕ್ಟೆಡ್
ಇದೆ ಮೇಡಮ್ ಇದೆ
ಆಫ್ಟರ್ನೂನ್ ಅಲ್ಲ ಬರ್ಬೋದಲ್ಲ ಥ್ಯಾಂಕ್ ಯು ಸರ್
Plus one
We are
point
only-
is that,
Yes.
please, my lords.
Yes.
Plus one point is that, my lords, this property in question belonged to deity, my lords. From past 1960, my lords, till 2001. Only in the year 2001, it was granted to respondent number 4, who is the who claimed to be the archaka of this deity, my lords. Other than that, my lords, there's one citation, my lords, I'd like to produce, if your lordship permits. Lords, in this matter, my lords, lords, it is clearly held that, my lords, with respect to state's right to auction property of the temple, my lords, once the land is vested in the deity or temple, the state cannot have a right to auction the property of the temple. Auction in the sense, my lords, also, my lords, the occupancy rights granted in respect of respondent number 4 is also, my lords, it doesn't come into consideration, my lords. In also, my lords, there's one more, my lords, paragraph number 22, my lords. The contrary view expressed by the High Court of Gnansham Das, Sadashivgiri and Sri Krishna, my lords, does not lay down good law in view of a binding precedent of division bench of the High Court in Pancham Singh, as also in the Court of Panchayam. All this judgment presenting a contrasting view had not noticed the said binding within dealing with the rights of priest and Revaluation. This, my lords, now, my lords, in this judgment, my lords, it is clearly observed, my lords, that right to alienate properties of temple, Pujari cannot be treated as Bhumi Swami, my lords. Pujari does not have any right in land and his status is only that of a manager. Right of Pujari do not stand on same footing as that of a tenant, my lords. Also, my lords, name of collector as manager cannot be recorded in respect of property. Vested in deity as collector cannot be manager of all temple unless the temple is vested with state. This is the only submission I like to make, my lords. Leave it to your lordship. The villagers are in very much hardship, my lords. The existence of the temple is itself in question. They already now, my lords, the respondent number 4 has already transferred the said property in favor of his daughter. Has made a gift deed, my lords.
Yes, sir.
Please.
So dismissed with cost of rupees 50,000,
Lords, I'll be
out of which 25,000 is for frivolous petition and 25,000 is for
My lords,
arguing a matter which was
please.
supposed to be withdrawn.
My lords,
No
humble
cost,
submission, my lords.
only instead of 5015 total. Cost will be there.
My lords, please, my lords, I kindly request, my lords.
Like dismissed.
I'll withdraw, my lords. Please, my lords.
No, will not permit you to withdraw.
My lords,
That is too much. No. Dismissed.
This cost may not be implemented, my lords. I kindly, my lords,
Says withdraw.
much obliged.
Number 20, to Joseph Kanikrat.
Appear for the appellant's claim. There is a delay of 106 days. I have informed the other side is present.
Or learned Mr. Francis of the applicant, learned so and so of the respondent. The present application is filed seeking to condone the delay of 106 days, which has taken place in filing the appeal. Full stop. Explaining the passage of time leading to delay to the aforesaid extent, it was submitted that after the judgment and order of a single judge, the applicant appellant filed review application, which remained pending for some time and came to be disposed of on 5/8/2024. It is thereafter that on 13/8/24, the writ appeal came to be filed. Paragraph. On the basis of the above primary aspect, it was submitted that the petitioner applicant was litigating bona fide and there was no element of indolence on the part of the applicant. The appeal was preferred as soon as the review petition was dismissed. Paragraph. In the facts of the case, and any of the reasons supplied, it could not be said that the applicant whiled away the time for the sake of whiling away. Full stop. The ground submitted makes out a sufficient cause to condone the delay of 106 days. Paragraph. Accordingly, delay is condoned, application is allowed.
We are filing the contempt petition, they filed the appeal is proceeding on merits of the matter.
Want to argue? Want to argue today? Like, argue.
Next statement.
Ready? You are ready?
Next statement. Any day, man.
Not now.
With the concurrent finding of the labor court and the single judge on facts that there is refusal of employment. That is being challenged here, my lord. And also, my lord, one more thing is, Berkman died, my lord, and is represented by his wife and his children only. And the court has only granted him back wages till the date of his death, after he came before.
You want time. When shall we keep?
Any date convenient.
18th March.
Please, ma'am.
Number 58. Mr. Ranganath S. Joyce. Number 58.
What is there? You are there? You are there?
Complainant.
What is it about?
In this matter, my lords, complaints has been done, my lords. The lordship has me 2 days time, my lords, and I file my complaints affidavit. Endorsement has also been already been dispatched to the complainant, my lords. I pray for 2 days time, my lords. Pertaining to fixation of pension, my lords, the grievance of the petitioner has been complaint has been complied, my lord. That has been dispatched, my lords. I think it's not been communicated to him. I'll file my complaints affidavit, my lords. I pray for 2 days time, my lords. I'll file my affidavit. I have tomorrow or day after tomorrow.
At the request of learned additional government advocate, Mr. Raghavendra, stand over to March at 2:30.
Please, obliged.
Seal number 85. So 230 matters. Mr. Jagan Mohan MT. For
So you are withdrawing? 85 for withdrawal?
Complied.
Complied with? Amount is refunded.
Complainant has personally visited the office of the PD and collected the amount. Time is found on
The direction in the order of Learned Single Z dated 15th December 2022 was that the respondent shall take necessary steps to cancel the allotment of the shop in question in favor of the petitioner and refund the amount with applicable interest. Today, when the petition came up for consideration, learned additional government advocate, learned advocate, Mr. Chinmay, full name. So and so filed for the respondent filed memo dated 18/2/24 stating that the amount of rupees 4,55,4334 has been returned and the complainant has received the said amount. Copy of the demand draft dated 14/2/2025 bearing number 609736 is produced. Full stop. Any of the above? It could not be disputed by learned advocate of the petitioner, Mr. So and so, that the direction is complied with and the refund amount is refunded, which is received by complainant as well. Nothing survives in the present contempt petition. It is accordingly disposed of.
Number 86, Vinita PC.
Lordships, I care for complaining. And the other day, Your Lordship, I directed the government advocate to find out the situation, I mean, what my grievance, it was a partial compliance where Your Lordship could recollect where the swamp was there, they have put a private road to reach to the stream where the bund has been, which has been enacted by the third party. And to that extent, I have given a representation to the respondents. And the respondents, Your Lordship, only to the extent of that bund, they have removed. And in their objection, Your Lordship, they state a compliance. They have said very clearly in paragraph number 3, there is no stream. And the deputy commissioner, she directed for to hold in a survey. In the survey, they have found that there's a stream and they have issued a notice to remove that bund. And accordingly, only the bund has been removed. And as for the swamp is concerned, Your Lordship, that is with respect to the fire fencing, because that is in a forest area where they have put, I mean, loads of mud and completely closed down the swamp, and they have closed the, that is where they have closed the fire fence. Now the petitioner's, I mean, complainant's land being adjacent land, because of these fire fence getting closed, these opposed to the wild animals. This Nagarhole National Park is adjacent to the complainant's land. That is where, Your Lordship. And on the other day, after Your Lordship has directed the government advocate to get the instruction with regard to that, they have gone and only the very same photograph they have taken, and which Your Lordship could permit me, and I would submit to the, if Your Lordship could permit me.
Filing additional complaints affidavit, my lords. Lordship was pleased to observe on the last occasion, my lords, that the endorsement given earlier, my lords, was not in proper, my lords. Now on 14/2/2022, my lords, with the relevant facts, my lords, on 17/4/2024 itself, the Panchanama was conducted. The same was communicated by the range officer to the deputy conservator of forest, explaining, detailing everything, my lord. And on 14/2/2025, now the endorsement has been issued, my lords. Your lordship was pleased to observe that the act has been transferred on the other person. Now your lordship may kindly see my compliance affidavit, my lords. The endorsement issued by the lordship may kindly see, my lords. On 14/2/2024, my lords, the said endorsement has been issued, my lords. Your lordship should get it at page number, my lords, 14, my lords, annexure R11. Before that, the Panchanama was also conducted on in the year back itself, my lords. That is on 17/4/2024, my lords. The same was not brought to notice of this honorable court by the complainant, my lords. Subsequently, my lords, by a communication letter dated, my lords, 17/4/2024, the entire facts has been detailed out and was addressed to the deputy conservator of forest, my lords. Now on 15/2/2025, endorsement has been issued, my lords.
Very much what compliance they are, the government advocate submitting, where very much in their own compliance affidavit, they have said in paragraph number 5 and 3, the very same thing again they have now what they have filed the.
It is not compliant.
The swamp, I mean, which they have completely put a mud and closed it. So fire fence, there is no fire fence at all. And my estate is thrown to the wild animals.
There is no.
That is the swamp. That is the swamp which they have put mud and they have completely closed it. Only to facilitate the third party to get the irrigation, where I have the photograph now, which I have produced at the other page number, where they have installed the motor permanently, just only to facilitate, just because, Your Lordships, only thing is that the third party is being an IAS officer. These respondents are not considering. That is where my writ petition was allowed and to consider my grievance. My grievance was very clearly, Your Lordship, was specified that closing down the swamp and closing my fire fence, that is the grievance. So they have only to hush up that one grievance of mine. They have only after my petition is allowed, they have gone and inspected only that bund has been removed from the stream. Now, the photograph very clearly it depicts, Your Lordships, where the swamp is completely closed by dumping. My other rejoinder, Your Lordship, where the Hitachis and all these vehicles, where they have come and dumped the muds. Loads of muds have been dumped in that swamp and completely closed. which apparently it is a fire fence. Lordship, my rejoinder to the earlier compliance which is filed on 22/7/24, where I have produced the document also to support that there is a swamp. The commissioner report also. And in that rejoinder, your Lordships, page number 16. There is no swamp at all right now. Now they completely putting mud, made it a private road. Just to reach to their motor where their irrigation facility has been done to their estate, some third party. And after the last date of hearing, as your Lordships have instructed to get instruction from the officials, and they did go to the place and nothing has been done. They just, the same thing as it is. And I have produced, that is where I have produced the photographs, your Lordships. And that fence, which is that where the new fence has been erected, that is from a third party. This is totally a forest land. And it is a swamp.
Who will remove this?
Make one submission, my lords.
Machinery.
I make one submission.
Which respondent is responsible?
Forest official, respondent number 3, your Lordships. The conservator of the range forest officer and the deputy conservator of forest, accused number 2, 3 and 4, your Lordship.
So what about this photograph?
Please, my lords, your lordship, my lords, for a moment, my lords, if my lordship takes my earlier compliance affidavit, page number 28, my lords, for a moment.
Some machine is there.
The first compliance affidavit on 23/4/2024, my lords. In that page number 28, my lords, the photographs were produced in my earlier compliance of affidavit, my lords. On last occasion, my lords, my lordships was pleased to see that the bund was not cleared. To that effect, an endorsement issued to the contesting party, my lords, that was not appreciated by this honorable court, that you are passing on your liability and the other persons. And it was said that it we consider it as a representation and issue an endorsement. Now, your lordship may kindly compare the photographs filed on earlier compliance.
Deputy Assistant Conservator
Right.
Forest. Kodadu may remain present. He may remain present.
My lords,
This Assistant Commissioner may remain present personally.
please, my lords.
Learned additional government advocate states before the court that he will keep present the Assistant Conservator Forest person,
Please, my lords.
since he is not able to assist the court. What kind of government advocate you are? That you are telling that you will remain, keep the officer present. We have no objection. If you are volunteering to bring your officer here
No, my
for
lords.
contempt,
No,
welcome.
my lords. My submission was that, my lords, the endorsement
Take
has.
that we are recording it, Mr. Counsel. No, this order is gone. Order and time goes, never comes back.
I'm sorry, my lords,
Will you satisfy us?
No, my lords, my submission was that assistant conservator.
Useless submission, we are not inclined to entertain. You show that why this machinery is lying, why this sump is lying.
My respective submission is honorable court was, my lord.
So then let the order remain.
I apologize, my lords. My submission was that, my lords, that the compliance has been done and endorsement was been issued to the.
You satisfied that why this photograph still shows that there is a machinery, the road is not cleared. Call your officer and get the instruction.
I'll take instructions, my lords.
3rd of March, 2:30.
Please, my lords.
Unless you satisfactorily explain to the court, we are not going to
Please
leave the matter.
Please move. I'll take
Even if
instructions.
you are there, you are right. It's your duty to explain it to the court to satisfy some of the court.
Please.
Not in your own way, go on speaking, which is hardly relevant. Yes,
So number 87 to
yes,
Manjunath
what is it?
AB.
Lord, this is a matter wherein
What is the direction?
the government has issued an endorsement saying that the land falls within 18 kilometers from the city limits, my lord. Therefore, the
Yes.
On last occasion, my lords, I submitted to honorable court that the land of the petition was falling within the limits of the municipal corporation, my lords. And the lordship has said that is there any circular or amendment giving the power to the deputy commissioner to scrutinize the document even before placing before the screening committee, my lords, your lordship recollect. With regard to regularization.
We
my
don't
lord.
recollect, you explain. Mr.
Please, may I pass this orders, my lords?
My lord, it should be from the date of the application, my lord, not from the date of the order, my lord. I have documents to show that the very same Tahsildar has given.
So what is to be done? Committees are formed?
No, my lord, not.
Why it is not formed?
My lords, that while the applicant's application was screening, my lords, it was found ineligible, my lords. The application of the complainant, my lords, was found ineligible, my lords, because the land which he was seeking for regularization is falling within the limits of the corporation, my lords. So the deputy commissioner had a power to reject his application even before placing before the screening committee, my lords. To that effect, my lords, there's a government order and also been amendment, my lords.
We have passed such order in one of the matter. Where is that?
Please, my lord.
713 of 2020.
If it is ineligible, where is there a question of?
No, my lord, that is not the case, my lord. What has happened is these, what they're saying is wrong, my lord. As on the date of the application, my lord, the distance should be calculated from the date of application, my lord. As on that date was 24.5 kilometers, my lord. My lord, I don't have the translated copy, but I have the very same Tahsildar who has given an endorsement, my lord, on 2011, my lord. If I may, my lord.
Who will decide that it is?
It should be placed with
the deputy commissioner. That is
no, my lord.
Who will decide?
Under the
Self will decide that.
no, my lords. Your lordship may kindly see my complaints affidavit, my lords, at para 4, my lords.
No.
Under the Karnataka Land Revenue Act, my lords, section 94A, my lords, says that, my lords, any land falling within the limits of 18 kilometers of the municipal corporation, my lords, not eligible for regularization, my lords. That is what I have stated in my statement.
Let the committee decide it.
No, my lords. To that effect, my lords, even before placing the matter before the committee, screening committee, my lords, the deputy commissioner has the power to reject the application, my lord. That is what lordship.
We are saying that place before the committee.
But the government circular says that, my lord, that initially, my lord, the document has to be scrutinized by the deputy commissioner, my lords. Then only that it has to be placed before the screening committee, my lords. Even before that, if it is found application.
No.
In many districts, my lords, the committee itself is not formed wherever the lands fall within the 18 kilometers radius. The act itself prohibits, my lords, granting of the land or regularization of the land. So only in cases where the lands are beyond 18 kilometers or the districts which falls beyond 18 kilometers, committees are formed.
Decide that it is beyond or within 18.
On the date of application, not today.
My lords, the government, my lords, the Office of the Principal Secretary has issued circulars, my lords, to that extent. And the very act says, my lords.
What says that the principal secretary, Department of so and so revenue is directed to take steps to have the necessary committees constituted in the state on or before 15/12/23 for considering the application filed by the regularized unauthorized application. Committees to be so formed are directed to consider it. Now you are scuttling the formation of committee and say the commissioner will decide whether eligible or not.
See, counsel,
Please, my lords.
while deciding this matter, the government advocate was specifically asked to take instructions from the principal secretary of the concerned department and make a submission when the government will be in a position to constitute the committee. In fact, on the date of passing the judgment, your principal secretary appeared through video conferencing also. And it was told that the date was fixed in consultation with your principal government, your principal secretary, 15/12/23. This judgment was passed on when?
On 20th June 20.
July 23. we gave the government 6 months times to constitute the committee. Just for political reasons, you have not been able to constitute the committee. What should happen to scores of applications that are pending before the committee, number one? Number two, this contention was never taken when the matter was taken up for hearing, that there are certain matters which are beyond, within that 18-kilometer range. So that you could have rejected it either way initially itself, which was never done. It shows 100% slackness on part of the government officers. They are playing with the lives of farmers. The committee ought to have been constituted immediately after the government comes into power. How many years up?
1.5 years.
Then what were you doing so far? What type of administration is this? Why should we not haul you up?
My lords, with regard to the consideration of application, my lords, by circular, by letter dated 29/9/2020, my lord.
And the writ petitions are filed from 2017 and onwards. This order has been passed in a writ petition. What order? The committee should consider that particular form filed by them. That's all.
Please, my lords.
And you don't do it.
I make one submission, my lords. On 29/9/2020, my lords, with regard to the screening of the application, my lords, the power was given to Deputy Commissioner to first, before placing the application before the screening committee, my lords, to find out the eligibility of the application.
Different aspect.
Please, my lords.
Why committees have not been constituted so far? What type of administration is this? If you want, you can constitute the committee in one day.
Few places, my lords, committees have been found, my lords, in.
We want our direction to be complied.
Please, my lords.
If earlier order is passed, at least I am concerned, I never follow my order when it is found to be wrong.
Please, my lords.
So earlier order you don't depend upon, don't rely on. It's a clear direction in this order to form a committee and then place the applications before the committee. So it has to be done in the manner it is required to be done, in no other manner.
As regard to the application of the complaint is concerned, my lords, I'll secure instructions pertaining to the whether a committee is.
No
formed.
instructions, we want committees to be formed and their applications to be considered and compliance of the order.
I'll take instructions, my lords, if some time is granted.
You may have big considerations, but we believe that it's small order to be complied with.
I'll take instructions, some time may be granted. my
Take
lords.
instructions.
Please, my lords.
When? Day after tomorrow.
Week's time, my lords.
Otherwise, we'll call your secretary.
Please, my lord. Next week, my lords. Any day next week, my lords.
No, next week. 27th,
Please, my
2:30.
Okay.
Case number 88, Amit Xavier.
Oh, my lord, appearing for the complainant. My lord, on the
Fine.
previous occasion, they have filed the compliance affidavit, my lord. I just did an inquiry with the complainant. He had not received the documents which is filed by the learned government advocate, my lord. Hence, I may request the learned friend to produce the tracking number so that I can just do an inquiry with the post office, my lord. Because they have not received
No,
the.
but some compliance is fine.
Lords, there was a representation, my lords.
It is decided.
It has been considered. In the representation, they have asked for certain documents. That has been given, most of them is given. One is not given because it is not available in our office.
Who has asked? He has asked.
Yes, complainant has made a request. That is the representation. Lords, in our compliance affidavit also, we have stated that we have given all the documents and an endorsement also has been issued, except one, my lords.
I did an inquiry with the complainant, my lord. He had not received these documents because these are
something-
certified documents.
Put something on affidavit.
I'll get the tracking record.
Yes,
that
my
he
lord.
has.
The next statement.
6th of March.
Oblige, my lord. Oblige, my lord.
Yes.
Case number 89, Madhukar M. Deshpande.
For the petitioner in this case, but yes,
In this matter, my lords,
today there was a matter listed before my lords, my lord, concerning this contempt petition, my lord, RP number 248 of 2000.
Time has been extended, my
This
lord.
is a
Yes,
matter
ma'am.
where
In
yesterday
view of
review
that
petition,
particular,
lordship extended the time. Therefore,
We have
yesterday matter was listed review petition.
auction.
please, my
Auction,
lord,
my lord.
auction.
We have
Time
conducted
has
the
been
auction.
extended.
But in view of that, this contempt petition.
Contempt may not survive, my lord.
Survive.
The order is available? Not available.
No, it's not yet uploaded.
No, ma'am.
Lordship extended by 3 months, my lord, to conduct a fresh auction.
Must have been uploaded by now today. Yesterday I've sent. Anyway. So which is that matter in view of?
248.
RP 248
RP
2020.
2020.
RP number
248
of 2020.
2020.
Please,
2020.
please, ma'am. I have the.
Yesterday order was passed. Day
Please,
before.
yesterday.
Today the order was
Yesterday.
passed. 17/2/2020.
Learned advocate Miss
Maheshwari
Maheshwari
for
the-
Madhukar Deshpande. For Madhukar Deshpande.
for petitioner
Please, ma'am.
fairly stated that in view of the order dated 17/2/2025 passed in the review application number 248 of 2020, whereby the court extended time to hold the auction for 3 months.
Please.
From the present contempt petition would not survive. Of learned additional government advocate Srimati Pramodini Kishan concurs with the submission, who stop in view of the joint statement made. The present contempt petition is disposed of as not surviving.
Oblige.
So number 90. Sridhar Murthy HR.
The accused has issued an endorsement.
Yes.
Contending that the documents produced before him are not tallying with the records in his office.
Lots of fresh endorsement has been issued on 17/2, my lords. Wherein they have submitted certain documents on 14th, And we are in the process of considering those documents, my lord. This is the fresh endorsement issued in both the
In
cases.
fact, on 14th, the revenue inspector of the accused who is working under accused has called the petitioners and requested to file fresh application with certain documents that has been produced on 14th.
It is in respect of some 4D and a sketch.
Yes, yes.
My lord, it's under
They will
consi-
do it within 8 weeks and will
Please,
please.
dispose it of.
That's, no, I request some, keep it pending. They may issue something, endorsement similarly for that.
Learned additional government advocate Srimati Pramodi Nikisan states that the directions are that the compliance of the directions of learned single judge is underway. Full stop. In that you stand over to when? 4 weeks?
4 weeks,
1st of April.
Both matters, 1991, both matters.
both the matters.
Both matters, 1991.
Both. 90 and 1991. Both. Same order.
Pledge.
Number 92, Mr. Vedamurthy MV.
Yes.
I appear for the accused number 3, my lord, in this case.
This is what appeal? Contempt. 92. With contempt. Yes.
Ample submission, my lord. There is some office objection with regard to the respondent number 2, my accused number 2, my lord. But one Mr. Chandrasekhar Dodmani was there when the order was passed. Before the order could be communicated to him, the present incumbent is transferred and he has taken the chair, my lord. And therefore, the wakalat of the present incumbent is filed and the affidavit of the present incumbent is filed, my lord. Therefore, the office objections may kindly be overruled, my lord, and the proceedings may kindly be continued in the against the present accused number 2, my lord. Because he has the access to all the records and files, my lord, documents. The office objection is purely technical in nature, my lord. Therefore, my humble submission to your lordship, it may kindly be overruled.
What is the office objection? Wakalatnama filed by advocate. What is the office? So then the Wakalatnama doesn't tell it then, Mr. Counsel. Oh. Complainant. So you are for complainant?
Yes, ma'am. We are appearing for the complainants.
Accused, my lord.
The matter is very short, my lord. The similar pay anomaly has been considered. They have accepted it. Court has observed it. It has to be given. Against that order, they are in appeal. I am in contempt.
Well, at office of shall be removed within 2 weeks to be listed on 1st, 27th March.
This is number 93, Mr. Venkatesh S. Sarabati.
With regard to the validity of a rule, Copy. Very copy. The Lokaयुक्त Act is blocked. We are aware about that. And the division bench took the view in another case that in all matters where the investigation is done by Lokayukta, only Lokayukta should hold inquiry. Now the learned single judge judgment is directly contrary to that. May I just pass on that judgment? Division bench took the view, though the word may is used, in all cases where Lokayukta conducts investigation, they themselves should hold inquiry. That is, the officers who are working under the Lokayukta should hold inquiry. That is the view taken by the division bench. Now the learned single judge holds exactly the opposite. And he also holds double jeopardy. Double jeopardy would only arise when there is a prosecution and punishment. Neither there is a prosecution nor there is a punishment. It is only a recommendation given to the government. By this method, my lord, the entire Lokayukta becomes virtually
Two more, because at least speaking for myself, not read the matter, so that anything to be discussed tomorrow will take call.
May I please, Lordship. Notes, I may not,
Urgency.
for the serial number 93 is concerned, notes, I have filed a Vakalat notes on Thursday. Also, I appeal for the petition notes is concerned. 94 minutes, the party has given notes to Vakalat notes, yet to file a Vakalat. Notes, may just request notes the few minutes readable copies notes at least. So that notes I get ready minutes for that.
Pardon?
Notes, I have not yet filed minutes Vakalat insofar as not serial number 94 is concerned.
File it.
Please, readable copy me kindly be put.
no, whatever he wants, we'll give. Our matter is
Tomorrow, but they have real serious urgency, will take up the matter. Come at 2:30. Tomorrow, which date?
Tomorrow, 19th.
19th. Who appear for the state?
state would be sailing with us.
Yeah, but it's important for the state to participate in the proceedings.
Correct. State
Otherwise,
also, is a rule made by the state only.
Not been arrayed as a party.
correct.
Happens here, this is the KPTCL matter. Identical rule is there in the central, state civil service rules also. In fact, the learned judge should have heard the state government also. On the basis of this judgment, no inquiry can be done by local.
If this is confirmed, then that will also go.
That will also go.
That will also go.
Which judgment?
But this judgment,
So
Take care, take.
and you sleep blissfully
I have filed
without filing an appeal.
No, I have filed my lords.
That's what my strong objection is.
No, I have
Disciplinary
filed.
authority minutes.
I have filed my appeal and I will give the writ petition. now.
We don't know. You may be hand in glove with petitioners.
No, my lord.
You means your officers.
No, definitely not, my lords. I have filed an appeal. I have filed an appeal. Through my office it is.
in this para division bench judgment, para 10 and 11, the court holds that only Lokayukta should conduct an inquiry. My lord. Para 11, at page 5144. In the present case, inquiry is initiated under Rule 11 of the CCA rules. Further, it has come on record that investigation was made by Lokayukta under Lokayukta Act, and the report and recommendations are forwarded to the government. The government has also found that it is a case for initiation of inquiry for major penalty. Therefore, inquiry is ordered under Rule 11 of the CCA rules. But such inquiry was required to be entrusted as per observation made above to Lokayukta or Upalokayukta as the case may be, not to any called high power committee. The decision on the part of the government for getting inquiry undertaken Rule 11 of the CCA rule. In a case where investigation is made by Lokayukta and report has been forwarded by Lokayukta to government, could be said in contravention of Rule 14A 2A2 of the CCA rule. Hence, initiation of inquiry, including charge memos forwarded, both can be said to be without any authority of the law. So, court holds, though the word may is used, they shall entrust it to Lokayukta. Now the learned judge, my lord, holds that in a case it will lead to inevitable bias, whereas the Supreme Court in several cases, just as in the case of anti-defection to be decided by a speaker, Public Premises Act to be decided by an estate officer. In all these cases, courts have said this is not an individual personal bias, it is an institutional decision. That being so, the question of inevitable bias which the learned judge holds, my lord, is not, none of the Supreme Court judgment deal with this inevitable bias.
We'll bring those judgments on that principle, any other judgment.
Yes, my lord. I have made a compilation.
Pass it over then.
And the statistics may also help.
Yeah.
If you can produce the statistics regarding where it has been referred and it has ended in favor of the delinquent employee.
Book. In Kyoto loans case, that is where the speaker is required to decide.
The statistics of Lokayukta to substantiate your statement, where inquiry is recommended by Lokayukta, it is conducted by the deputy registrars or additional registrars as the case may be, and ended in favor of the delinquent employee.
That is also there.
DGO.
Secondly, my lord, it is given to the government.
No. What I'm telling is, if you produce those statistics, that itself will speak for itself.
That also, my lord, we can.
That there won't be any bias.
Correct. That statistics also we can produce. There, my lord, at page 113.
Because after
that will produce. In this Kyoto law, my lord, page 712.
712.
Para 113. Para 113. It is also urged. Para 113.
Yes.
It is also urged that a speaker under Indian parliamentary tradition is not required to resign his membership of the political party on whose strength he gets elected, and that inevitably the decision of the speaker is not free from the tucks and pulls of political polarization. It is urged that the speaker who has not resigned his membership of the political party cannot be impartial, and at all events his functioning will not be free from reasonable likelihood of bias. The 10th schedule breaks away from constitutional pattern for resolution of disqualification envisaged in Article 103 and 192 of the Constitution, which vests jurisdiction in his behalf in the President or the Governor, acting according to the opinion of Election Commission. The disqualification for defection could very well have been included in 1021 or 191(1) as a ground, additional to the already existing grounds, clauses A to E, in which event the same dispute resolution machinery would have been dealt with the disqualification for defections also. But the 10th schedule apparently attempted a different experiment in respect to this particular ground of disqualification. The question is whether investiture of the determinative jurisdiction in the speaker would by itself stand vitiated as denying the idea of an independent adjudicatory authority. We are afraid the criticism that the provision incurs the vice of unconstitutionality ignores the high status and importance of the office of the speaker in a parliamentary democracy. The office of the speaker is held in the highest respect and esteem in parliamentary traditions. The evolution of institution of parliamentary democracy has as its pivot the institution of the speaker. Speaker holds high important ceremonial office. All questions of the well-being of the House are matters of Speaker's concern. Speaker is said to be the very embodiment of propriety and impartiality. He performs wide-ranging functions, including performance of important functions of judicial character. But after giving all this, para 118 is the conclusion. It would indeed be unfair to the high traditions of that great office to say that investiture in it of this jurisdiction would be vitiated for violation of a basic feature of democracy. It is inappropriate to express distrust in the high office of the speaker merely because some of the speakers are alleged or even found to have discharged their functions not keeping with great tradition of that high office. The robes of the speaker do change and elevate the man inside. Accordingly, the contention that vesting of adjudicatory function in Speaker's chairman would by itself vitiate the provision on the ground of likelihood of political bias is unsound and is rejected. Speaker's chairman hold pivotal position in the scheme of parliamentary democracy and are guardians of the rights and privileges of House. They are expected to and do take far-reaching decisions in the functioning of parliamentary democracy. Vestiture of power to adjudicate questions under 10th schedule in such constitutional case should not be considered exceptionable. Similar, my lord, is a view taken by the Supreme Court in a case where this motor vehicle transport, where the minister hears the objections, my lord. The court was of the view, if the minister hears, can it be said that he is in favor of the state government? Court said no in Kondala Rao's case, my lord, in AR 61 Supreme Court. Minister, even though minister hears, he cannot be considered as a person who is biased in favor of the government, placing reliance on Gullapalli Nageshwar Rao's case. At page, is it? Yeah, same thing is it? There in paragraph 13, at page numbers are there on the top, page 9. That's page 8, para 13. Para 13, on the right-hand side, my lord, there is a reference to Gullapalli Nageshwar Rao's case. At paragraph 13, right-hand side. After that Gullapalli Nageshwar Rao's case, at page 9, there is a reference to Gullapalli Nageshwar Rao at about 10th line from the top. Page numbers are at the top. There, after that, there as in this case, you lot have got it. Chief Minister who was in charge of the portfolio of transport could not be a judge in his own cause, was the allegation, as he was biased against private operators. This court pointed out a distinction between official bias of the authority, which is inherent in a statutory duty imposed on it, and personal bias of the authority in favor or against one of the parties. Then there is a quotation. In dealing with official bias, the court, after considering relevant English decision, these decisions show that in England a statutory invasion of common law objection on the ground of bias is tolerated by decisions, but the invasion is confined strictly to the limits of statutory exception. It is not out of place here to notice that in England, Parliament is supreme, therefore statutory law, however repugnant to the principles of natural justice, is valid. Whereas in India, the law made by the Parliament or state legislature should stand the test of fundamental rights declared in Part 3. Then, my lord, that H.C. Narayanappa's case also is quoted, where the government, para 14, there is a quotation from H.C. Narayanappa's case. I'll read that quoted portion in para 14. It is also true that government on whom the duty to decide the dispute rests is substantially a party to the dispute. But if the government or the authority to whom the power is delegated acts judicially in approving or modifying the scheme, the approval or the modification is not open to challenge on a presumption of bias. The minister or the officer of the government who is invested with the power to hear objections to the scheme is acting in his official capacity. Unless there is reliable evidence to show that he is biased, his decision will not be called in question merely because he is a limb of the government. In this case, Lokayukta makes the recommendation. Officers of the cadre of sitting district judge or retired district judge who will conduct the inquiry. On that inquiry, Lokayukta forwards his recommendation. Government can pass a final order, it is left to them. Government is the disciplinary authority. It is only our role, my lord, as a Lokayukta. Initially also is only a recommendation to the government. Government thereafter entrusts us We have an inquiry wing where the sitting district judges, retired district judges are there. They will conduct inquiry. Thereafter, my lord, some of the district judges are deputed by the High Court also, and all of them are judicially trained. Not that, my lord, they would know, would they, I think all of them would know the difference between a recommendation and an inquiry where issue will have to be decided on the basis of the material evidence placed. Thereafter, matter goes to the state government. State government, my lord, will have to pass an appropriate order. Sometimes this court has taken the view, state is not bound by this recommendation also. If it is a case of minor penalty, it does not come to us at all. Government itself will impose the minor penalty. Now, my lord, the court holds, in fact, the propositions which they have framed, my lord, I will just pass on the questions which they have formulated in the by the learned single judge, only for a immediate reference. In fact, this is the question, my lord, which they have posed in various pages. I have given the page number also. A is aspects to be determined to judge the validity of a subordinate legislation, general proposition, where the regulation 14A results in inevitable bias, which in turn renders the regulation manifestly arbitrary in direct contravention of Article 14 is thus unconstitutional. This conclusion, my lord, the court says there is inevitable bias. This is contrary to several Supreme Court judgments. Whether regulation 14A would contravene the principles in Article 22 of the Constitution of India, this learned single judge says yes. Lord, this is very surprising, Lord, this conclusion. Merely because we said a recommendation, where is the question of double jeopardy in a service matter? Then D, whether a conflict of interest arises within different wings of Lokayukta vis-a-vis the recommendations of the Lokayukta. Whether inquiry officer would be in a position to take an independent view of the matter. Whether the recommendatory role of Lokayukta under the Act be transgressed if it is permitted to punish a public servant for misconduct. We don't punish, we only hold an inquiry and forward it to them. Whether Lokayukta can be given the power to hold inquiry when it has chosen to not exercise power conferred on it to prosecute a public servant for criminal offence under Section 14 of that. Let the learned judge says, if you don't prosecute, I cannot hold a disciplinary inquiry at all. Section 14 enables us to prosecute, but I may not prosecute in a given case. Whether Lokayukta can play the dual role of a prosecutor as well as an inquirer. I am not prosecuting anybody in this. On these questions, the learned judge answers all the issues against us. And in fact, earlier ACB was there, and this honorable court held that Lokayukta hands to be strengthened, and the ACB was abolished and the powers were given to Lokayukta. Now what was given away, given to us the Lokayukta in one hand is being taken away in this. Our entire inquiry wing, will become jobless. In fact, that ACB judgment says that hands of Lokayukta needs to be strengthened. There is one para in that judgment, which this is the case where ACB was created, Anti-Corruption Bureau was created. That was questioned at page 90, para 230. At page 90 at para 230. 230, paragraph, page 90, para 230. Page numbers are at the top. The provisions of KL Act, that is Karnataka Lokaya, which is enacted for eradication of evil of corruption and maladministration, must be construed liberally so as to advance the remedy. In our opinion, there is absolutely no merit in the impugned executive order passed by the state government in the powers under the provisions of Article 162 of the Constitution of India, and the impugned order cannot be sustained. It is also not in dispute that before enacting Karnataka Lokayukta Act, public opinion has been agitated for a long time over the prevalence of corruption in the administration. It is likely that cases coming up before independent authorities like Lokayukta or Upalokayukta might involve allegations of actual evidence of corrupt motive and favoritism. We think that the institutional Lokayukta should deal with such cases as well. Then para 231 also, they refer to the Lokayukta. Then at page 232, para 232, 233, Para 233. As already stated supra, the object of Lokayukta Act and Prevention of Corruption Act was to achieve common object and goal of corruption-free society. Common man has immense faith in the institution of Karnataka Lokayukta and also its police wing. That too after handling investigating relating to mining scam. Earlier, the common man could have filed complaint against anybody to set the law into motion under PC Act, and there was no bureaucratic impediment or decision required to initiate the proceedings against a complaint. However, ACB was set up abruptly with an intention to take control of the pending investigation against high functionaries of the state bureaucrats, etc., in order to protect and scuttle the investigation against political class and bureaucrats. Government order dated 14/3/2016 came to be issued constituting ACB as an authority for investigation under PC Act. Thereby, the very purpose of Lokayukta Act was indirectly defeated. As per the provisions of Code of Criminal Procedure, the complainant himself should not be an investigating officer. As per the impugned executive order, if any complaint filed against Chief Minister or the Minister in the Council of Ministers, Chief Minister himself has to oversee the investigation and permit investigation. Thereby, impugned executive order is opposed to the rule of law and contrary to the dictum of Honorable Supreme Court in the case of C. Rangaswamy. The impugned government order constituting ACB empowers the Honorable Chief Minister to veto investigation of or in the sanction of investigation. This itself defeats the very purpose of the anti-corruption drive. And ACB is not at all an independent body. The police force of ACB works under the authority of Honorable Chief Minister. And any independent investigation is only a mirage. No serving officer would be in a position to conduct an inquiry against the Honorable Chief Minister under whom they would be working as subordinates. Therefore, by the constitution of ACB, the basic investigation apparatus mechanism is dysfunctional. ACB is constituted virtually to defeat the very purpose of PC Act itself. State is bent upon saving its corrupt ministers and officers, and therefore the impugned government order and subsequent supporting notification are contrary to the very object of KL Act. The constitution of ACB is one without authority of law, though it purports to create an independent wing, is controlled by the Honorable Chief Minister. Thus, Lokayukta police force is virtually abolished by creation of ACB. The state government issued the impugned government order constituting ACB on an erroneous understanding of judgment of Honorable Supreme Court in the case of C. Rangaswamy. In fact, the said judgment curtails the power of state government to constitute ACB or any alternative mode of investigating agency and interfere with the functioning of Lokayukta. The statutory powers assigned to Lokayukta and Upalokayukta under the provisions of KL Act cannot be diluted by the executive orders passed by the state government under Article 162 of the Constitution of India. After the constitution of ACB by way of executive order, state government issued notification dated 19/3/2016, thereby superseding earlier notification dated 6/2/91, 8/5/2002 and 5/12/2002 that authorized Lokayukta police with powers to investigate and had declared the officers of police wing of Lokayukta as police stations. Then, my lord, the court holds ultimately.
Now, this judgment does not say about Rule 14A, sir.
It doesn't say about Rule 14.
This is
but
with
only
regard to
thing is,
ACB vis-a-vis Lokayukta police. That has no bearing over here.
there is in the next page, my lord, what they say is there is a recommendation to strengthen the hands of the Lokayukta. The only point which I am trying to make is Lokayukta, my lord, is an independent body which will decide cases. It cannot be said that it is prejudiced this way or that way merely because there is a recommendation. The word itself says recommendation, my lord. It is left to the government ultimately. There is no power. In fact, Supreme Court says Lokayukta's report should be complied with. Legislature should be amended to that effect.
We'll start at immediately after recess tomorrow. Yes, give me all this.
Will copy be provided, but so that I get ready.
They'll serve. Who are you? Who are for?
I am the petition, Lord.
I think. Your original petition.
Please,
Be here, we'll continue. Be ready with the matter.
I mean,
The matter of public importance, not.
please. Suddenly.
Both sides will consider. Not.
Please, sir, suddenly.
So you be ready, that's all. Welcome to argue. On behalf of state also, we would call upon who will be appearing.
Need your stand.
Lord, in this matter, we have not been arrayed, my lord, in this matter as a respondents. State has not been arrayed as a party.
The state is not arrayed, but.
Though there is a
root
challenge
also-
to section 14A, my lord, the state has not been arrayed as a party.
Right. But the net effect of this order is that your rule also will be invalidated. So
Correct.
you need to file a.
We need to
leave
take a
appeal.
stand, my lord, no doubt about it.
State is not a party because this is a KPTCL rule.
KPTC.
Who has adopted state rule?
The present writ appeal. The present appeal. Referred by the registrar, Karnataka Lokayukta. Is directed against judgment in order of learned single judge dated 16th October 2024. Whereby learned single judges declared regulation 14 capital A of the, what is this KP? Karnataka Electricity Board into the CDCA regulation to be unconstitutional, and the same is struck down.
That rule is identical to.
Since in the proceedings, the state is not a party. However, looking to the importance and the ramifications of the subject matter controversy, the appellant is directed to implead the state government
Further, Ballot.
party so as to enable the court to be apprised of the stand of the state government.
Further, Ballot.
The
This
first
rule
title
is.
of the appeal shall be accordingly amended, and copy of the set of the appeal, entire set of the appeal shall be made available to whom will appear,
I shall appear.
learned additional government of the Harish.
The rule in question is similar to Rule 14A in Karnataka CCA rules also.
Civil services,
So therefore, state would be.
full stop. We'll add that line.
Let me to make that amendment now.
Yes, right now you can take it.
Great. In both appeals.
Both.
My lords, one submission, ma'am. I appear for the corporation. I have also filed an appeal, my lord, that may be tagged along. I'll also.
Very good. Get it listed to.
Yes, ma'am.
Seal number 95, Mr. Mahendra SS.
I appear for the petition. In this petition, I am filing memo for withdrawal in view of the subsequent amendment made to KMMCR law with the liberty to avail that remedy of revision. This amendment came into effect after filing of this petition.
After filing of petition.
Yes.
In this petition filed under Article 226 of the Constitution, the first prayer was made to direct Respondent 3 to comply with the amended Karnataka Minor Mineral Concession into bracket Amendment Rules 2023 and extend the validity of the petitioner's co-release for a term of 30 years, giving effect to the grant as per notification dated 1/1/13. Full stop. The attendant prayer was, the next attendant prayer was to set aside an order of Respondent 3 dated 7/1/2024. It was thirdly prayed to set aside order dated 8th October 2015 passed by Respondent 3 cancelling the notification dated 1st January 2013. And consequently to set aside the order of the joint registrar dismissing the division application. Full stop. Today, when the petition came for consideration, learned advocate Mr. S.S. Mahendra for the petitioner filed memo dated 18/2/2025 by submitting that during the pendency of the present petition, Sub-Rule 1 of Rule 18 of the Karnataka Minor Mineral Concession into bracket Amendment bracket Rules 2020 was brought into force, and the said rule was brought into force, which provides the remedy for filing revision application. Full stop. The memo for withdrawal paragraph reads as under. Quote the memo. Full stop. In view of the above, permission is granted to withdraw the present petition, reserving liberty for the petitioner to avail the remedy of filing revision application in accordance with law, in respect of which, however, this court does not express anything on merits. Full stop. The petition is accordingly disposed of as withdrawn, with liberty reserved as above. Okay. Add one line before that. Learned additional government advocacy Nilofer Akbar has no objection to the withdrawal of it on the aforesaid count. These three not taking. Follow.
If I may, my lord, there's some matters in the third list which only notice needs to be issued.
That we are not taking up today, any other day will take. But lot of delay applications are there.
Yes, in some of them, fresh matters are there, 4 of them and all, in which only notice needs to be issued to the others.
So we'll issue notice.
Yes, my lord.
In those matters, delay matters.
Yes.
Notice returnable on. When shall we keep? 24th of March?
Please, my lord. 24th March.
Both by hand and also.
That this is that paragraph.
International Workers Matter. Provident Fund.
So what is held by learned single judge?
My lord, learned single judge has held that paragraph 83 is unconstitutional for the reason that it artificially creates a separate category of workers called as international workers, for which there is no provision under the
EPF Act.
EPF Act.
That is completely strange to the objects are to achieve another intent.
It's
And
totally
whenever
against
the,
objects and aims and objectives of the EPF and MBA.
You are for whom?
I am for Union of India, Manoj.
Class of those workers who are excluded.
Please,
He
madam,
is
there is-
representing some of the employees and the employer.
What is the stand of the employer?
My lord, the petitioners were employers along with their international workers.
We had filed the petition, madam.
Yes.
Along with international workers.
Yes, some of them,
Along with a few
because what they have argued is that contribution towards their provident fund must be dispensed with simply because these are citizens of countries abroad. They draw high salary. PF Act is not meant for high salaried people, which ex officio is incorrect in our submission.
We'll thresh out. It will require some lengthy.
Yes, my lord. 24th March, my lord observed. Grateful.
Obliged.
Notices will be added.
My lord,
Notices will be added.
By hand also.
Office objections may be removed before the next.
We'll do that.
Wherever it is to be removed.
Have been removed.
Office objections to be removed before the next date, wherever.
Any of the list, respondent number 3 is not made as a party because he is not a necessary party in the present proceedings for the time being. Hence, I have filed a memo in 4 cases.
Doesn't matter.
Those, that can be, because that's only office objection, nothing else.
All
And he's not a necessary party to that effect. I have.
on that day we'll dismiss, don't worry, don't worry about it.
Obliged, my lord, obliged.
Madam.
ಒಂದೊಂದೇ ನೋಡ್ತಾರೆ ಅಲ್ಲಿಂದ ಪಡಿಬೇಕು. ಹಾ ಸರ್ 21, 15, 21, 22 by both ಹೌದು.
ಎಲ್ಲೆಲ್ಲಿ ಯೂನಿಯನ್ ಆಫ್ ಇಂಡಿಯಾ ಅಂದ್ರೆ ನಮ್ಮ ಹೆಸರು ತೋರಿಸಿ. CGSPC.
Do we need to put in our appearance now?
ಇಲ್ಲ ಸರ್, ಅದು by hand over writ petition, ಅದೇ same order in wherever the judge is passed.
ಈಗಿಲ್ಲ, after a week we will make.
Sir, this-
887% marks.
Yes, that should lead back. Do we need to put in our appearance, sir? Thank you, sir.
That's on that day, on that day.
We need to give our appearance separately. Our appearance.
Yeah, appearance names. No arguments. Board of ಎಷ್ಟು ಟ್ರೈ ಮಾಡೋದು ಗೊತ್ತಾ? ಬರ್ಲಿಲ್ಲ, ಅದಕ್ಕೆ ಬಾಯ್ ಹಠ ಆಗ್ಬಿಟ್ಟಿದೆ. 19 on the 15 on. Advocate counsel who has appeared before the London proceedings are ಮಾಡಿದ್ದೀನಿ already. Last time ನಾನು ಮಾಡಿದ್ದೆ.
24.
ಎಲ್ಲಿ ಮೇಡಮ್? ಡೆಲ್ಲಿ time being what are ಅದೇ ನೀವು ಮಾಡ್ತೀನಿ, ನೀವು ಅದ್ರ ಕೇಳಿದ್ರಲ್ಲ ಬರೀಲ್ಲ ಅಂತ ನಾನು ಕೊಡ್ತೀನಿ. ಹೌದಾ, ಒಂದ್ ನಿಮಿಷ
ಸರ್. ರೆಡ್ ಎಲ್ಲ ಸರ್, ರೆಡ್ ಪೆನ್ ಎಲ್ಲ ತಾನೆ ಬರೀಬೇಕಾಗಿರೋದು.
ಡೇಟ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀರಿ.
ರೆಡ್ ಪೆನ್
ಯಾವ್ದಾದ್ರು ಇದು ಮಾಡಿ
ಫೋಟೋ ಫೀಸ್ ಸರ್,
ಗೌರ್ಮೆಂಟ್ ಅಷ್ಟೇ ಕನ್ಫ್ಯೂಸಿಂಗ್ ರೆಸ್ಪಾಂಡ್ ಯಾರಿಲ್ಲ.
ಫೋಟೋ ಫೀಸ್ ಸರ್.
ಬಂದ್ಬಿಟ್ಟಿದೆ ಅದು. ಅದು ಇದ್ದಿಲ್ಲ. ಯಾರು ಮೂವ್ ಮಾಡ್ಬೋದಾ?
ಹೌದು, ಹೇಳಿದ್ದೀರಾ?
ಹೋಗಿದ್ಯಾ ಏನ್ ಎತ್ತಂಗಿಲ್ಲ ಬೆಂಚಿದೆ ಬಾಯ್ಲಿ ಕೆಲಸ ಮಾಡಿ ಎಂತ ಫೋನ್ ಆ ಕಡೆ ಇದು ಆಯ್ತು ಮೇಡಮ್
ಸೈನ್ ಮಾಡಕ್ಕೆ ನಿಮಿಷ ಸೈನ್ ಮಾಡ್ತಾರೆ ಹಾ ಒಂದು ನಿಮಿಷ
ಹೌದಾ ಕೇಳಿದ್ರಲ್ಲ ಅದಕ್ಕೆ ಕೇಳಿದೆ ಒಂದ್ ಸೆಕೆಂಡ್ ಮಾಡ್ಕೊಟ್ರೆ ಸಾಕಲ್ವಾ ಇವಾಗ ಸದ್ಯಕ್ಕೆ ಓ ಅದಕ್ಕೆ ಕೇಳಿದ ಸರ್ ಹೇಳಿದ್ರಲ್ಲ ಒಂದಿದ ಆಯ್ತಾ ಅಂತಲ್ಲ ಅದಕ್ಕೆ